May Your Lordship,
Yes.
Your Lordship, I beg to mention item number 26. I'm appearing behalf of Gakenjini.
Item number
Appellant 26 Your Lordship. 26.
26. You are Mr.
I'm Sita Jo appearing behalf of Gakenjini, Your Lordship.
Mr. So and so, Learned Counsel. Appearing on behalf of Mr. Z. Zini, Learned Legal Aid Counsel for the appellant. Price for listing the matter after
Your Lordship, 2 weeks.
2 weeks. Bear allowed.
Much obliged.
May Lordship. Lordship, I would like to mention item number 5, Lordship. Lordship, this matter may be fixed on 30, Lordship. I'm taking the consent from other side, Lordship. Petitioner side, Lordship. Applicant side, Lordship.
Item number 5.
5, Lordship.
Okay.
Lordship, one connected matter is not listed. That is double lane number 2. This is double lane number 1, Lordship. Both are connected to each other, Lordship. This mean. Double lane number has to be listed along with this, Lordship.
Okay. Mr. Z. Bam, Learned Counsel for the respondent with consent from the other side. Price for listing the matter on 38th of March.
Yes, Lordship.
38th of March. Bear allowed. Mr. Tapin, Learned Counsel for the appellant. Learned Senior Government Advocate for the appellant submits that one connected matter being WA number
2
of
2026, Lordship.
2026 has not been listed along with this matter, though both the matters are connected. And accordingly, he has contended that registry may be directed to list both the matter together. Where allowed, registry shall list WA number 2 of 2026 along with WA number 1 of 2026 and list both the matters on 30th of March.
Lordship, the interim pass earlier may be continued.
Interim order passed earlier shall continue.
Obliged.
Much obliged.
Lordship, I'd like to mention this one WPC matter for listing for tomorrow. The urgency is that in previous date the respondent.
Single bench matter or DB matter?
It's DB matter, Lordship.
Tomorrow, what urgency is there?
In previous date, the respondent government said they're supposed to file an affidavit, but it's been a long till now they didn't file any affidavit.
We'll consider it on day after Thursday on.
Thursday, if DV is there, then okay.
Yes, Thursday DB is there.
Okay, then Thursday.
Thursday.
Your Lordship, I'm mentioning item number 1, Your Lordship. Your Lordship, I'm seeking an adjournment for today, Your Lordship. The main counsel is out of station, Your Lordship.
Who is the conducting counsel?
K. Tari.
Okay. Miss, your name, please.
After 3 weeks, Your Honor.
Your name.
Oh, pardon, Your Honor. Tirini, Your Honor.
Learned counsel appearing on behalf of Mr. K. Tari, learned conducting counsel for the petitioner. You inform the other side? You inform the other side?
Yes, Your Honor.
Other side, I'm there. Well, I'm sorry, my sister she didn't inform me. Anyway, if your Lordship sees my last order, they are supposed to file some additional affidavit, my Lord.
Yes.
Yes, my Lord.
Yes.
And which they have not yet filed, my Lord.
Okay. Press for listing the matter after
3 weeks, Your Honor.
after 3 weeks as conducting counsel Mr. K. Tari is out of station.
Yes, Your Honor.
We are allowed to list the matter after 3 weeks.
Yes. Obliged.
My Lord, in item 21, today's item 21, there is an IA filed by the respondent number 7. We have, this morning, we have filed our objection to the IA. That may be called, my Lord.
Okay.
Item number 2.
May I please, Lordship? Lordship, this public interest litigation has been filed by the organization Anti-Corruption Foundation, Arunachal Pradesh unit through its state president. So the petitioner organization is engaged in public interest work relating to promotion of transparency, accountability, and prevention of corruption in public administration, especially in the state of Arunachal Pradesh. So the grievance of the petitioner organization in this case is that it's related to project titled Construction of Water Conservation Project at Ali Senyi Stream under Yachuli Block, Kai Panjur District, for which public fund amounting to rupees 2.50 crore has been sanctioned under Article 275, Clause 1 of Constitution of India by Department of Justice, Empowerment and Social and Tribal Affairs through its order dated 08024 or 2024. So, Lordship, going through before going into this order, sanction order, I would like to tell this court that prior to filing this this public interest petition, the respondent organization has filed a price before the various concerning authorities for addressing their issue, wherein the exact case of mine is that though sanction has been given in the year 2024, but still till date no actual work has been carried out, which the petitioner organization on dated 5/2/2026, just 1 month back, they have personally visited this spot and verified that there is no actual work has been carried out. Not even 10% of work has been carried out, but it is learned to them that the government is going to release the fund. So in that respect, prior to coming to this writ petition, we have submitted various representation. Total five numbers of representation we have submitted since from 2025. So first representation we have submitted is before, it's a complaint.
What was the completion period?
Completion is, the project is tenure for, specified tenure is for 1 year.
1 year.
Yes, yes.
So within 1 year, they ought to have completed the same.
But tenure is written, that exactly I don't know, but tenure is in copy, in document it is given 1 year. So in that sense, we can assume that
No,
it has to be
whether the
completed
period of
within 1
1
year.
elapsed or not.
No, that is not been left, I think, because they are
Been
trying to release the amount.
No, the amount has also not yet been released.
Yes.
Then how this petition is meant?
Because lastly, because this one, last, the 052 of this month, this year, we have done a physical verification, and even we have met to concerned executive engineer, PWD, and they have told the petitioner organization that the fund will be released. And recently, 2 days back, I think, Deputy Commissioner, concerned Deputy Commissioner Kai Panjur has directed to release the fund. Though it is not in our document, because 2 days back, that direction has been issued from Deputy Commissioner. So this is my case. But in this case, no actual work has been. So, Lordship, this, I will like to go through this order dated sanction order 08/08/2024. It's in page 50. 50.
52.
50.
Bukan number, na?
50.
So you have also filed one representation to the Superintendent of Police Anti-Corruption Bureau, Itanagar.
Yes, Lordship, I am coming to the total number of 5 representation I have filed. I have filed a form of
5.
total 5 SP Anti-Corruption Bureau.
Now, whether the Superintendent of Police Anti-Corruption Bureau has registered any case?
No action has been carried out whatsoever in manner.
Mr. Nabang, whether any information is available with you?
My lord, since this is coming for the first time, my lord, I have to take instruction. My lord, in lieu of complaint lodged by them, any course of action is taken or not, my lord. I have to take the instruction, my lord.
Okay.
This PL is coming for the first time, my lord.
Yes.
So if your lordship wants, my lord, I can take the instruction, my lord.
Okay. Let him obtain inspection. Yes.
Or else, my lord, notice may be issued since there is a private respondent. My lord, if your lordship passes any order, my lord, he'll be the angry person without hearing him, my lord.
Notice.
Notice may be issued as it is, my lord.
Actually, Lordship, this is the financial end year, and so these payments are usually released in this period. This March 31 is the last financial end, and there is a great apprehension that the fund bill is going to release within this month only. So that is so we are emphasizing from this honorable court to grant at least interim may be passed till verification, no funds should be released. If verification of work is done, then release. Our claim is only that one. So protection of public fund is to be upheld, Lordship.
Yes.
My lord, what I have seen, my lord, if your lordship see, my all the representations submitted by the petitioner, my lord, it's only pertaining to non-payment of the, my lord, bills to the contractor, my lord. They are not exactly saying, my lord, what poor quality, my lord, what is the DPR, whether they have followed the DPR, nothing like that. But anyway, it's submitted, my lord. Your lordship may say, my lord, subjected to, my lord, if they have done the work, my lord, then payment can be released, my lord. Subject to the satisfaction of the authorities, my lord. If they have done, my lord, they are entitled for payment, my lord. If they don't have done anything, my lord, they are not entitled, my lord. So that, my lord, restriction you lordship may, my lord, put, my lord. Subject to the satisfaction of the authority, my lord. If they have executed work, my lord, then payment may be released, my lord. Or else, my lord, returnable debt, my lord. We can take the instruction what course of action the SP has taken, my lord, or the, my lord, executive engineer, my lord, who is supervising this work, my lord. We can take the instruction, my lord.
Lordship, then
I'm sure,
instruction.
my lord, without any execution of work, my lord, not a single penny will be released.
No,
I'm
they have enclosed some of the photographs. At page number?
Photographs, my lord, these are.
Five तक क्या? देखो तो photograph को index में देखो. Index देखा है? बस.
Page 89, my lord.
और
My lord, it's very difficult to ascertain, my lord. These are the, my lord, exact place, my lord.
Lordship, it's page 85 and 89. One is along with junior engineer, the concerned junior engineer. Actually, this work is about regarding 6 numbers of water conservation pond has to be constructed. But in here only, I think you will just slight earth cutting is there, but it's not as per the specification because as per the map and drawing, it has to be depth has to be 4 meters, length and breadth is to be 90 and 40 meters. So prima facie, looking into this picture, there is no such 6 pond. Even if I go through this earth excavation work also, there is nothing is there in this photo. And there is Lordship, and Lordship, I will like to take Lordship the page number 71 and 72, Lordship. This is the drawing map. Drawing map, Lordship will find, see that drawing is given, length is given.
What is the sanction order? Page number?
Page 50, Lordship.
50.
May Lordship read that page.
Construction of water conservation project.
And Lordship, this project has to be constructed in the stream, but there is in photo itself there is no stream, because this project name itself is Water Conservation Project at Early Senyi Stream, and this drawing also here is given that water will come from upper stream. It will come from stream. Upper portion, it will come, it will be outlet,
Mm.
inlet, and lower, down portion, downstream, it will be an inlet.
Mm.
So where is the stream? There is no stream. So constructing, only digging that will not suffice for this project. Lordship.
Mm.
So what I am showing, I'm trying to show this honorable court is that, prima facie my case is that this entire project cannot be carried out in this situation, in these circumstances.
Okay, heard, Mr.
And
My
Saha.
lord, just a minute, my lord, so far, my lord, this, your lordship have just seen the, my lord, order, my lord,
Mm.
that is as Agar, that must be the sanction order.
Mm.
My lord, name of the scheme, it says, my lord, he's right, my lord, construction water conservation project at E. Sinji streams.
Mm.
Now we say streams, my lord, now the water has to be, my lord, diverted from the stream and is to be stored, my lord.
Mm.
Then there has to be a channel, my lord.
Mm.
And channel is under construction. Then the art cutting, you lordship seen the photograph, my lord. Art cutting is going on,
Mm.
where my lord, water will be storage, my lord.
Mm.
So my lord, project is on, not yet completed, as per the photograph annexed by the petitioner, my lord.
Mm.
Now, Lordship, for that, I have given the clarity in page 71, where it is given that water will directly come from stream. It's a,
So there has to be channel for
yes.
bringing to that for conservation place, my lord. There must be a channel, my lord.
Mm.
We cannot divert the entire stream, my lord.
Mm.
But
There has to be
as
some
per
channel,
the,
my lord.
I am not going any assumption, hypothetical submission. I'm not. What is there in the map? I am only saying that one. Here, this channel area, this design is not been given in this drawing.
Mm.
If that was supposed to be part of that, that was to be given. But in drawing, it's not there. It's only given the upper stream.
Mm.
That water will come from that upper stream. And Lordship, this one, why this project was meant? The very purpose of this this project was Lordship will see, Lordship may kindly see page 75. Sorry, Lordship. Lordship may kindly see page 79 of this petition, which tells the why this purpose of this project.
Mm.
So I will like to read this report portion, which is there in middle of the document.
Mm.
The history, this detailed estimate amounting to rupees 232.38 lakhs, rupees 2 crore 32 lakhs and 38,000 only is framed to cover up the probable cost of above mentioned project and to obtain necessary technical sanction from this authority. Actually, Circle is facing acute scarcity of water, so the construction of water conservation pond is utmost necessity to preserve water during rainy season for dry season, for which water conservation project at Eli Senji stream has been proposed. So this is the very purpose why this project has been come up. This project has come up because there is a scarcity in the entire Rizali town, town. So if this project is siphoned in this public fund for this project is siphoned in this way, then the ultimate sufferer will be the locality only.
Mm.
So my humble submission is that whatever fund is going to be released, release after doing verification. My only limited submission is that I'm not trying to halt this project. You carry on the work, but do the verification and take the fund.
Heard, Mr.
And Saha.
Learned counsel for the petitioner, Mr. R.S. Naba. Learned additional advocate general for the state respondent, being
One-
respondent number
1 to 8,
1
my lord.
1 to
1 to 8.
1 to 8,
9 is private respondent.
1 to 8. This public interest litigation is instituted by Anti-Corruption Foundation, Arunachal Pradesh unit, represented by its secretary,
State President,
Tana Roma,
Para.
his secretary,
State President.
State President of State President Sri Tana Roma Tara. The grievance being sought to be addressed in this public interest litigation by the petitioner is that the Social Justice and Empowerment and Tribal Affairs Department, Itanagar, Gautam Arunachal Pradesh, has sanctioned a sum of rupees 2 crore 50 lakhs for the financial year 24 and 25 for construction of water conservation project at Eli Seni stream under Yasuli block of Lower Subansiri district, Arunachal Pradesh. Against the grant released under proviso to Article 275, which in bracket 1 of the Constitution of India by the Ministry of Tribal Affairs, Government of India, sanctioned during 23-24, subject to the restriction of fund as per availability during the CFY 2024-25, and the said sanction amount approved by the Ministry of Tribal Affairs, Government of India, and also complying with the conditions stipulated in serial number 1 to 8 of the order dated 8th of August 2024. Mr. Saha, learned counsel for the petitioner, submits that the object of sanctioning the said project was that Yasuli Circle is facing acute scarcity of water. So the construction of water conservation pond is utmost necessary to preserve water during rainy season for dry season, for which water conservation project at Eli Saini stream has been proposed. And thereafter, the said project has been approved and expenditure sanctioned under SJETA for a sum of rupees 2 crore 50 lakhs for the current financial year 2024-2025 has been sanctioned. But the work was allotted to respondent number 9.
Yes, Lordship.
Respondent number 9, MS Zeti Enterprise, represented by Sri Toko Raja. But drawing the attention of this court to the photographs at page number 85 and 89. Mr. Saha submits that only some earth cutting.
Minor earth cutting.
Yes.
Minor earth cutting.
Yes.
Oh, okay, Lordship. No problem.
Submits that that due to field verification conducted by the organization of the petitioner at the project site on 5/2/2026, he found that the work reflected in official record does not correspondence with the ground reality, and no functional water conservation infrastructure capable of retaining water throughout the year is visible at the site. And the site appears to be consist largely of excavated earth formation without any permanent engineered structure as envisaged in the sanction estimate. And Mr. Saha further submits that though the petitioner organization has submitted several representation and complaints before the Superintendent of Police Anti-Corruption Bureau, the Secretary to the Social Justice, Empowerment and Tribal Affairs Department, and other competent authorities for seeking verification of the project and withholding of fund release pending inquiries, the same failed to evoke any response. And he further submits that as per his information, within this month, the respondent authorities are going to release the fund to the respondent number 9. Respondent number 9. Mr. Saha further submits that if the fund is released without actual execution of the sanctioned project, would amount to arbitrary state power, misuse of public resources, and violation of the public trust doctrine governing management of the public fund. And under such circumstances, he submits that this notice may be issued and the respondent authorities may be directed not to release any fund to the respondent number 9, who has been entrusted to execute the work without proper verification. Mr. Nabam Learned, additional Advocate General for the state, respondent number 1 to 8, however submits that he may be allowed to obtain instruction in respect of the complaint and the representation filed by the petitioners to the Superintendent of Police Anti-Corruption Bureau and the Secretary of Social Justice, Empowerment and Tribal Affairs Department and other competent authorities. Then he further submits that the respondent authorities may be directed to make proper verification in respect of the execution of work before releasing the fund. Concludes at page number 85 and 89.
My lord, I have also submitted, my lord, as per this photograph, my lord, the execution of work is just started, my initial stage, my lord. It will be completed as per the DPR. Now, earth cutting, digging is on, my lord. Once the earth cutting is over, there will be laying of, my lord, road, everything, my lord, as per the DPRs, my lord. As per the photograph says, only the earth cutting is on, my lord. So that shows, my lord, the execution work is not yet completed, my lord. It will be completed as per the DPR, my lord.
No, what is the period?
The period, they said
1
year, my lord, 1 year.
Yes.
But I have not seen any, my lord,
Period is 24 and 25.
my lord.
That period is about to over.
Over, my lord, over,
The
my lord.
end of this month.
Correct, my lord. But when, my lord, the NIT was called, my lord, because that will be counted from the date of NIT, my lord, 1 year, my lord. So NIT not enclosed. And we are not aware of the DPR, my lord, what sort of, my lord, structure is to be, my lord, there, my lord. So all those things, my lord.
So, Chief, this,
Anyway,
it's not a complicated design. It's the drawing I have submitted. in,
No, drawing is all, there must be a
DPR
DPR.
is not part of the record.
No, it's not part of the record. my lord.
but detailed estimate which they have, it's sufficient for this court to prima facie look into this matter.
Let notice go at this
Let-
stage. You obtain instruction.
My lord.
But Lordship then till returnable date, this fund release may be installed.
Yeah, Lordship has
because-
subject
because-
to, my lord, verification. my
Lordship,
lord.
because day before yesterday itself, we have come to know that Deputy Commissioner has issued a letter to Director Sajeda for release of the fund.
Mm. Okay.
So that is the urgency why I'm emphasizing for that, Lordship, or else I won't.
Let notice be issued to the respondents, returnable in 4 weeks.
4 weeks.
However, no formal notice is required to be issued to the respondent number 128 since Mr. Nabam entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Step upon respondent number 9 be taken by speed post and also by usual process within a week from today. Pending further consideration. It is provided that the funds sanctioned in respect of the aforementioned project shall be released only after verification of the status of the work executed so far. List after 4 weeks.
Much obliged.
Item number 3.
My lord, the appellants in this case, they are casual laborers working as peon, chowkidar, pitar, maid, mason, WI, carpenter, driver, mazdoor, revenue collector, revenue attendant, mali, computer operator. My lord, the appellants, they are claiming payment of salary equivalent to the regular employee of their same cadre, as per judgment of the Supreme Court in Uma Devi case and Jagjit Singh case, my lord. My lord, they are claiming equal pay with the regular employee on the basis of equal pay for equal work. Because the regular employee and the casual workers, they are working the same nature of work. Suppose a pitter, suppose 5 pitters were there. 2 of them have been regularized. Even after regularization of their service, they are still working as pitter, and their work is interchangeable, casual labor as well as the regular employee. So on the basis of principle of equal pay for equal work, they are claiming equal pay with the regular employee. In this regard, I would like to rely on judgment of the Supreme Court in Uma Devi case, reported.
Whether you have placed the case of Uma Devi before the learned single judge,
Yes, my lord. Yes, my lord.
why it has not been considered?
Actually, my lord, let us see the judgment, operating part of the judgment.
Mm.
The relief that I claim in the writ petition, that has not been granted. Of course, some kind of relief has been granted to me, which was not sought for, my lord. And that is not sufficient relief for me. Para 18, my lord, page number 104.
Mm.
Page number 104.
Yeah.
Para 18. In the present case, having considered the matters in its entirety,
Mm.
it is noticed that the petitioners are provided with monthly wages akin to the minimum pay scale provided to the regular employee, holding the same post and in fact higher than the minimum pay scale. Thus, this court finds difficult in granting relief for payment of minimum pay scale and other service benefits as claimed by the petitioners. Next paragraph, my lord. Para 19. For the foregoing reasons, this court is of the considered view that no relief can be granted to the petitioner, as the petitioners are being provided the monthly wages by revising and enhancing the monthly wages from time to time by the state government. However, if the petitioners are not granted the enhanced monthly wages in terms of the order dated 19 March 2025, issued by the Commissioner of Finance, Government of Arunachal Pradesh, same shall be provided to the petitioners. This is the judgment of the learned single judge. My lord, salary enhancement has been done in such a way. Suppose regular employee was drawing salary, monthly salary of 10,000, initially 10,000. Only 2,000 enhancement has been granted. So this is not the relief that I have sought for. I am seeking relief on the basis of Supreme Court judgment in Umadevi case and Jagjit Singh case.
No, in which part of the judgment that decisions were considered by the single judge?
My lord, my lord, it has been observed in several paragraphs, my lord. Para 7, my lord, suppose. Para 7, page number 98.
That is your submission perhaps.
Yes, my lord.
The how the single judge has appreciated your submission.
My lord, after referring the submission made by me,
Mm.
only the observation made by the learned single judge is that I am not entitled to get salary equal to the salary of the regular employee of the same cadre.
No, Mr. Koyang, you see, first you have to establish that you are discharging the same function with that of the regular employee.
Yes, my lord. As I have cited an example that I have cited example of Peter, my lord.
No, that is all right, but whether the appellants herein are discharging the same function like the regular employees.
Yes, my lord. Some of them are peon, so and some of them are chowkidar. When they are holding different post or different category of post, my lord. Suppose Mali. Let us talk about Mali. As I have said earlier, suppose 5 Malis were there, and 2 of them have been regularized. Their services have been regularized, but still they are working as Mali. They are working together, both regular employee as well as the casual employee, and their services are interchangeable. So the nature of the work, quality of work, the same. It is the same of that of the regular. So I am entitled to get salary equal to the regular employee on the basis of principle of equal pay for equal work, my lord.
Mr. Tapin?
Yes. Lordship, on this particular issue, the law is that Lordship, now if the two employee, the worker Lordship, they are doing the same work Lordship, then Lordship, the wages equivalent to the lowest scale Lordship. That is what he is entitled as per the principle of equal pay for equal works Lordship. In the present case, if kindly Lordship turn to page Lordship, page 100 Lordship.
Yes?
Page 100 Lordship.
100?
100 Lordship.
Ah.
100. I am taking Lordship to the paragraph 13 Lordship. It talks about the recruitment rule of 2019 Lordship of this particular Lordship. What it provides Lordship, the general Arunachal Service Group C ministerial multitasking staff, Daftari, peon, chowkidar, mali, barber, cook, washerman, cobbler, and equivalent post. Common Recruitment Rules 2019 provides the pay scale of the said post of rupees 18,000 to 56,000 Lordship. The lowest is the 18,000 for the regular employee Lordship. Now kindly come to the paragraph 14 Lordship. As per our the scheme of the wages lordship, we have our own lordship policy, where lordship the worker are entitled for these wages as per their length of services lordship. What it provides lordship, kindly in column lordship can see from past year to lordship 5th year lordship, they are getting 19,000 per month lordship, and 5 to 10 lordship they are getting 20,000, and 10 to 15 they are getting 21,000, and 15 to 20 they are getting 22,000 per month lordship, and 20 to 25 they are getting 25,000 per month lordship, and above 25 years they are getting 31,000 lordship. So this is the consideration how the learned single bench has considered. The lowest pay scale of the lordship in regular cadre, they are getting 18,000 lordship. Whether you are being paid 31,000 per month, which is much higher than the lowest scale of the regular cadre lordship. So this is the how the learned single benches lordship consider. In this view of the matter lordship, kindly come to page 104 lordship. Even the Uma Devi, this case has been referred and that has been considered also lordship. Kindly see the page 104 lordship. I'm taking lordship to the paragraph just above paragraph 18. There is a lordship reference of Uma Devi case. There is paragraph 61 lordship. 104 lordship. In view of the proposition expressed by us in the foregoing paragraph, we have no hesitation in holding that all the temporary employees concerned in the present bunch of cases would be entitled to draw wages at the minimum of the pay scale at the lowest grade in the regular pay scale extended to regular employee holding the same post laws. This is the law. And then kindly see the paragraph 18. In the present case, having considered the matters in its entirety, it is noticed that the petitioner are provided with the monthly wages akin to the minimum pay scale provided to regular employees holding the same post, in fact, higher than the minimum pay scale. Thus, this court finds difficulty in granting relief for payment of minimum pay scale and other service benefits as claimed by the petitioner lordship. So what they have sought in their writ petition, we are paying more than that lordship. If still they want the lowest lower amount lordship, then we have no lordship hesitation lordship to grant that lordship. But we have our own scheme for the labor, the casual laborers lordship. The fixed wages are there, state notification. That is 8-page lordship, page 72 lordship. Page 72. This is the lordship policy of the state government, where lordship we have fixed the wages for this contingency staff and other labor. The payment is start from 19,000 to
Mr. Tapin, you see here,
lordship.
from years of service 0 to 5, it is 12,000 only.
No, lordship, revised one lordship. Kindly see the right hand
Revised
side.
one is 18,000.
Revised is 19,000 lordship. Page 72.
For unskilled, it is 18.
This is unskilled and skill is there lordship. Unskilled and skill. I was in skill side lordship. Even in unskilled also lordship. 18,000, 19,000, 20,000, 21, 38, 24, and 30 up to 30. Those are for the unskilled lordship. For skill on the right hand side, 19 to 31 lordship. In both the skill and unskilled, they are getting higher than the lordship, the minimum pay scale of the regular cadre lordship. So that's our policy lordship. Now, learned single bench.
No, this is not the scale.
This is not the scale. This is a fixed wages lordship.
Fixed wages.
Fixed wages.
The Honorable
So
Supreme Court.
is a-
Honorable Supreme Court also didn't didn't talk about the lordship scale lordship. They said the amount which is equivalent to the lowest scale lordship. Because those who are not regular lordship, they are not entitled for any other benefits lordship. They are only entitled for that particular salary only lordship, which is lowest in that cadre. If other benefits are included lordship, they will more like lordship, they will be kind of regular employee only lordship. The Honorable Supreme Court says lordship, the wages equivalent to the lowest scale lordship.
My lord, we have different interpretation. Let us settle the matter by the judgment of the Supreme Court. Let us see the judgment of the Supreme Court, my lord.
Yes, Jagjit Singh.
Please. We'll check, huh? Mula, okay, mula. Para 55, my lord. This is Uma Devi's case. Para 55 says, my lord. Second last page, my lord. In cases relating to service in the Commercial Taxes Department, the High Court has directed that those engaged on daily wages be paid wages equal to the salary and allowances that are being paid to the regular employees of their cadre in government service, with effect from the dates from which they were respectively appointed. The objection taken was to the direction of payment from the days of engagement. We find that the High Court had clearly gone wrong in directing that these employees be paid salary equal to the salary and allowances that are being paid to the regular employee of their cadre in the government service, with effect from the dates from which they were respectively engaged or appointed. It is not open to the High Court to impose such an obligation on the state, when the very question before the High Court in the case was whether these employees were entitled to have equal pay for equal work, so-called, and were entitled to any other benefit. They had also been engaged in the teeth of directions not to do so. We are therefore of the view that at best, the division bench of the High Court should have directed that wages equal to the salary that is being paid to the regular employee be paid to these daily wage employees with effect from the date of its judgment. Hence, that a part of the direction of the division bench is modified, and it is directed that these wage earners be paid wages equal to the salary at the lowest grade of employee of their cadre in a Commercial Taxes Department in government service from the date of the judgment of the division bench of the High Court. My lord, it does not say the scale pay. Learned counsel has stated that we are provided scale, pay scale,
They do it fixed pay.
fixed pay. As per that table, it is fixed pay. But as per his submission, scale pay. But even the learned single scale pay has been given. That means scale pay may be given equal to the date of the regular employee, but it is not sufficient. Other allowances are there. So as per this judgment, other allowances are also added.
No.
No.
My lord, this judgment says, my lord, actually division bench has directed to pay from the date of appointment, in the service. But that has been modified by the Supreme Court, that payment be made from the date of judgment of the High Court. But here it says allowances also. My lord, let me read it again. In cases relating to service in the Commercial Taxes Department, the High Court has directed that those engaged on daily wages be paid wages equal to the salary and allowances that are being paid to the regular employees of their cadre in government service. This is very clear, my lord. Salary and allowances, it says.
Read below also.
Then salary, with effect from the dates from which they were respectively appointed. The objection taken was to the direction for payment from the dates of engagement. So in the below, it is only clarified that payment be made not from the date of appointment.
See, come below. We find that against the salary and allowances, that are being paid to the regular employees of their cadre in government service. And below you see against that, we find that, read this one.
Yes,
We
yes.
find that the High Court had clearly gone wrong in directing that these employees be paid salary equal to the salary and allowances that are being paid to the regular employees. See?
My lord, it
Read that.
that is correct, my lord. It refers to actually the date of payment, dispute
That
is
is
date of
different
payment.
issue. That probably is different.
We find that the High Court had clearly gone wrong in directing that these employees be paid salary equal to salary and allowances that are being paid to the regular employee of their cadre in government service with effect from. So, my lord, if we continue till last sentence, it discusses about the date of payment from the date of appointment or from the date of judgment of the High Court.
That probably is different.
So it clearly says that salary equal to the regular employee with allowances, my lord. Now let us see Jagjit Singh case.
Read the below also once again.
Oh, just a second.
This
My lord, in
and
which part?
about the direction of the division bench.
As per
Last
the
part.
last part, no?
Mm.
Yes,
Hence that part of the.
hence, that part of the direction of division bench is modified.
Hmm.
And it directed that these wages earners be paid wages equal to the salary at the lowest grade of the employee of their cadre in the commercial sector. It says salary. When we say salary, it includes allowances, my lord. If we say basic pay, then it is different. When we say salary, it includes other allowances also, my lord. This should be correct interpretation, my lord.
Okay.
Monthly salary, suppose one is getting 75,000, but basic pay is less than that. So that 75 includes allowances also. my lord.
Daily wage earners
Yes, my lord.
be paid wages equal to the salary at the lowest grade of employee.
Yes, my lord.
So what does this mean?
The lowest grade means, suppose there are
We start from 18 only. The scale is start from 18 only.
18
I
means,
suppose this talks about that 18.
18 means,
The
my lord.
regular employee gets regular employee's scale starts from 18 only.
I don't
Daily
know.
wages earner be paid wages equal to the salary at the lowest grade,
Grade of employees of their
of
cadre.
their cadre.
Yes,
Yes,
my lord.
that's 18.
Yes, my lord. There is different, suppose let us discuss about grade, fourth grade. Fourth grade, there may be different pay scale.
And come there. Thereafter also, since they are, read this once, this sentence also once. Since they are only daily wage earner, there would be no question of other allowances being paid to them. See, what
Since
more
they are only
clarification?
daily wage earners, there would be no question of other allowances being paid to
You have
them.
to read the whole thing.
In view of our conclusion that the courts are not expected to issue direction for making such persons permanent in service, we set aside that part of the direction of the High Court directing the government
That was
to
enough. Paid to
consider their cases for regularization. We also noticed that the High Court has not adverted to the aspect as to whether it was regularization or it was giving permanency that was being directed by the High Court. In such a situation, the direction in that regard will stand deleted and the appeals filed by the state would stand allowed to that extent. If sanction posts are, these are relating to regularization, my lord. Then let us see Jagjit Singh case, my lord. Para 61 is relevant, my lord. This is of 2017 case, after Uma Devi case. Last page, my lord. Last page of the judgment.
Paragraph number?
61, my lord.
Yes.
In view of the position expressed by us in the foregoing paragraphs, we have no hesitation in holding that all the temporary employees concerned in the present bunch of cases would be entitled to draw wages at the minimum of the pay scale at the lowest grade in the regular pay scale extended to regular employee holding the same post, my lord.
Same meaning.
Mr. Tapin, you are not paying them the pay scale. You are paying a lump sum amount of rupees 18,000.
Yes, because in this pay scale means it varies from one particular amount to the particular amount loss.
Mm,
Now, which is the lowest loss here?
mm,
When the past and suppose say now we have regular employee, one person is a regular laborer loss here. Now we are paying a past salary loss here.
mm,
That is the loss, the lowest scale loss here,
mm.
excluding the other allowances. What salary he is entitled loss here? That loss here we are paying here in this case also,
Mm.
which is more than the loss of the.
No. Pay scale here, the Supreme Court states about the minimum of the pay scale at the lowest grade.
My lord, there is a judgment of Guwahati High Court also.
Mm.
Today, I have not brought that case. Learned counsel Mr. P.K. Tiwari was in that case.
Mm.
Otherwise, my lord, let us have adjournment today. Let me come with that judgment. That will clarify everything because it is the judgment of this court.
Lordship, here, suppose say in this case, Lordship,
Mm.
the pay scale of this particular
Minimum
category.
of the scale of pay.
No, for this particular
Mm.
Lordship, employees Lordship, pay scale starts from 18,000 to 56,000 Lordship.
Mm.
Now, what is the minimum pay scale Lordship here?
Yes, 18,000
18,000 Lordship.
plus other allowances.
Other allowances, if other allowances is given Lordship,
Mm.
here the Honorable Supreme Court said Lordship,
Mm.
other allowances cannot be granted to them Lordship.
Where it is stated.
That my senior friend has already read Lordship, paragraph 55 of the Uma Devi case Lordship.
Mm.
Paragraph 55 of the Uma Devi case Lordship.
Mm.
Just after year mark. Since.
Mm.
May I read Lordship this particular paragraph
Mm.
55 Lordship? This is the exception actually Lordship. This particular paragraph 55. Exception to the law laid down by the Uma Devi Lordship. Uma Devi is against the Lordship regulations of the service Lordship after illegal appointment Lordship. What it says Lordship, in cases relating to service in the commercial taxes department, the High Court has directed that those engaged on daily wages be paid wages equal to salary and allowances Lordship, that are being paid to the regular employees.
Whether the appellants herein are the daily wages or daily wage earner.
Yes.
They are Lordship kind of contingency Lordship temporary employees. only.
Contingency and daily wage earners are different.
Slight difference is there.
In that case, Lordship, this section paragraph 55 itself will not applicable to them, Lordship.
Maybe, but then this Jagjit Singh.
Jagjit Singh, if Lordship sees the Jagjit Singh case, Lordship,
Mm.
Lordship, this here also the same Lordship in view of the positions expressed by us,
Mm.
which has been already quoted in the Lordship impugned order also.
Mm.
In the foregoing paragraph, we have no hesitation in holding that all the temporary employees concerned
Mm.
in the present bunch of cases would be entitled to draw wages
Mm.
at the minimum of the pay scale
Mm.
at the lowest grade in the regular pay scale extended to regular employees holding the same post, Lordship. Here also it talks about the wages, Lordship. What has been directed? Wages has been directed to be paid.
No, wages at the minimum of the pay scale.
Pay scale. The wages, it would be, Lordship, wages only, but amount will be equivalent to the minimum of the pay scale, Lordship. What is the minimum pay scale, Lordship? 18,000, Lordship. Here, what has been directed? Wages to be paid, Lordship, but amount will be equivalent to the lowest pay scale, Lordship. Now, in this present, Lordship, case, what is the lowest pay scale, Lordship? It starts from 18,000, Lordship. 18,000 is the lowest pay scale, Lordship. In case of the petitioner's, Lordship, as I submitted, Lordship, we are paying, Lordship, more than 20,000, Lordship.
Okay. Yes, Mr.
Yes, my,
Oyang,
yes, my lord.
you produce the judgment, we will see.
My lord, the judgment in Umadibi case and Jagjit Singh.
No, these are before us now.
Yes, my lord. The judgment that I want to
No,
produce.
no, you produce that decision where it is stated that pay scale includes the other allowances also.
My lord, in this judgment itself, it is there, my lord.
Where?
In the first line sentence, my lord, 50 para 55. In cases relating to service in the commercial tax department, the High Court has directed that those engaged on daily wages be paid wages equal to the salary and allowances. Salary and allowances that are being paid to the regular employee of their cadre in the
No, that
commercial.
is not the finding of the Supreme Court. That is the
That is
observation
what
made by
the High Court has granted. And then against that, negating that the Supreme Court says that we find that the High Court had clearly gone wrong. Have you read this? Clearly gone wrong in directing that these employees be paid salary equal to the salary and allowances that are being paid. While referring the judgment of the High Court, the Supreme Court, this is what the Supreme Court says. Being paid to the regular employees of their cadre in government service with effect from the so-and-so.
My lord, in this case,
And it further says, it was not open to the High Court to impose such an obligation on the state when the very question before the High Court in the case was whether these employees were entitled to have equal pay for equal work. So this is the judgment of the observation of the Supreme Court. And then below also, you say that since they are only daily wage earner, there would be no question of other allowances being paid to them. Only minimum of the scale. The regular employee gets the scale from 18 to say 50. The minimum is 18. And what the Supreme Court has said here is the minimum that is the minimum of the scale, that is 18 without allowances, because they are not a regular employee, not coming from the interview, not a regular one.
yes, my lord.
This is only for the wages.
My lord, the scheme of the state government.
Yes.
It is on the
It's even
basis of
more.
length of service. It is on the basis of length of service. But here in the judgment of the Supreme Court, it is universally applied, irrespective of length of service, my lord.
Then it will go down again. The 19, you will not get the rest. It will remain as 18 only, then for all. So the government of the Arunachal government probably is given more, gone beyond 18. There is, see, 31 also. For a skill, from it starts from 19 only.
If,
Not the
if
minimum.
other allowances are not added, then it will be less than that has been provided. But I am claiming other allowances also.
No, other
Of the lowest cadre of
No,
same.
you have to satisfy the court. Then, in
you
that
have
case.
to satisfy this court that this scale also include other allowances.
My lord,
Let us fix it on next Wednesday. Oh no, sorry, Tuesday.
my lord, tomorrow itself,
No, not tomorrow. Tomorrow single bench is there.
my lord,
Then on Thursday.
my lord, I will be till tomorrow. We have festival, my lord.
No, maybe.
His
then in
lordship
the
knows
next week.
from 20 onwards we have festival. I will not be here for entire month of March.
Then in the month of April.
Let us have it on April. No
April.
problem.
Heard Mr. S. Koyang, learned counsel for the appellant, Mr. S. Tapin, learned senior government advocate for the state respondent. Place the matter for further consideration on 7th of April.
7, no, later than that. The festival is very long one.
Okay. 21st
Uh,
31st.
April,
31st April is okay, man.
21st.
Yeah,
21st.
21st.
I can.
All right, madam.
Okay.
21st April. Huh? Oblige, madam.
Yes, so as to include. So as on which Mr. Koyang has to satisfy that pay scale includes the allowances also.
Yes, madam.
Minimum pay scale.
Minimum.
Oblige, madam.
Item number 4.
Lordship, I'm praying for the adjournment of this matter. Though I'm appearing for the respondent number 5 hearing. However, this morning, my brother, Mr. V. Picha, called me and informed me that he will be appearing for the respondent number 1 to 4. Being the standing counsel for the RD department here. His name is not reflecting in the cause list and he's out of station. So therefore, he suggested me to get it adjournment. Your Lordship.
Who is for the appellant?
I have informed the appellant side. Your Lordship.
Oh, you have informed?
Yes, Your Lordship.
Okay.
Senior
Mr. Your name, please?
IBAM, Your Lordship.
IBAM, learned counsel for the
Respondent number 5.
respondent number 5 with concern from the other side. Thanks for listing the matter after
A week, Your Lordship.
after a week. Fair allowed, let's just list the matter after a week.
Much obliged.
Item number 6 to 20.
My lord, this is relating to payment of solution in the land acquisition. And there is a judgment of Supreme Court, whether that judgment covers the instant case or not, that much on the matter. My lord, page 285. This is the judgment of Supreme Court in Mihilani case.
Page number?
85, 285, madam.
Yes.
My lord, relevant paragraphs are at para 25, 26, and 28. Page number 295, my lord. Para 25, my lord. In view of the foregoing discussion, we direct that the respondents shall also be entitled to solution as well as interest in accordance with the provisions of the 2013 Act, my lord. Next para. The appellant shall ensure that any areas towards solution and interest wherever not yet paid are released to the landowners of the subject acquisition within a period of 3 months from today, my lord. Now, para 28, my lord. In respect of concluded acquisition, where compensation has been finally determined, accepted and disbursed, no reopening shall be permissible. The impugned judgment of the High Court is therefore set aside to that extent. In the division bench judgment, my lord, there was observation of the division bench that acquisition made earlier that can be reopened. That was there. But to that extent, that has been set aside by the Supreme Court. Now, next paragraph is very important, my lord. However, it says, however, next sentence, my lord. However, in all matters which remain pending either before the competent authority or before court, tribunal, the compensation shall be computed to include solatium and interest as above. Learned single judge has applied half of the sentence, my lord, while disposing of the matter. How my lord, let us see the observation of the learned single judge. It is at page number 306. 306. 306. Para 26, my lord. Para 26. 306, my lord. Para 26. It says, my lord, in the instant case, the acquisition and compensation matter of the petitioners were finally settled and not pending before any authority. Being so, the interpreting the decision of Supreme Court in different way and reopening a closed matter is an abuse of judicial process. And thereafter, writ petition has been dismissed, my lord. Here, my lord, learned single judge has applied half of the sentence. It says, not pending before any authority. But in the judgment of the Supreme Court, it says, para 28, my lord. I'm reading para 28.
So, on the date of pronouncement of the judgment by the Supreme Court, this proceeding was pending before this.
Before this court, my lord.
Okay.
And in this regard, your lordship,
So, it is your contention that this your case is covered by the second part.
second part.
All
After
matters which remain pending either before the competent authority or before a court struck
court
tribunal.
tribunal. Yes, my lord.
Tribunal.
Had the learned single judge had applied the entire sentence, the judgment would have been in my favor, my lord. Because this matter was pending before this honorable court, high court. In this regard, your lordship may find order of this honorable court. Last page, my lord. It starts from the second last page, but the relevant para is last page. Later on, the learned counsel for the petitioner appears and informs this court that similar matters pending before the Honorable Supreme Court, being special leave petition C number so and so, hence prayed for listing this matter after disposal of the said SLP. So this is a clear case of pending before the High Court while the matter was pending before the Supreme Court. My lord, the para 10 of the single judge judgment, this is also erroneously held, my lord. Let us see. Para 10, my lord. This is at page 302, my lord. He further submitted that this is a case of concluded acquisition process, wherein compensation has already been disbursed and accepted by the petitioners before filing the present writ petition. He further submitted that at the time of disbursement of the compensation amount, the petitioner never raised the issue of payment of solatium, and the compensation amount was accordingly accepted by all petitioners. More so, from the notices annexed along with the present petition, it also reveals that the petitioners have issued notice to the Deputy Commissioner seeking solution at the rate of 100% of the compensation amount only after the order passed by the Honorable Supreme Court in the case of Mihin Lalin Supra, and prior to that, there was no prayer for solution by the petitioner. Notices were issued after pronouncement of a judgment in the Supreme Court. That is erroneously held, my lord. The case itself was filed in 2023, annexing the notices. So, if the learned single judge had appreciated that notices were issued before the Supreme Court judgment was pronounced, then it would have been different judgment. It would have been in my favor, my lord. So this kind of erroneous holding is there in the impugned judgment and order of the single judge, my lord. In the Mihin Lalin's case also, it was filed after receiving compensation, my lord. After receiving compensation when solution was not paid, then only Mihin Lalin approached before the High Court, claiming for payment of solution with interest. So this is the similar case, that of the Mihin Lalin case. So the judgment of the Supreme Court squarely covers the present case, my lord.
Yes, Mr. Ratan.
I don't know. After my lord's judgment in Mihin Lalin case, many concluded acquisition processes. Based on my lord's judgment, they also started claiming. This is one of the classic examples. My lord will kindly come to page 62. Page 62, there the acquisition was in the year 2013. The acquisition process. They were given the compensation, paid the compensation. After 2013, there was no any agitation by the against the quantum of compensation by the petitioners. They were happy, but
No, that's all right.
yes, and then in the year 2023, first time.
Mr. Ratan.
Yes.
Here the issue is whether his case is covered by the observation made by the Supreme Court in paragraph number 28 or not.
Yes, my lord. His case is a case of concluded acquisition.
But
yes, my lord.
But writ petition was pending before this court.
Yes.
While passing this judgment by the
Yes.
Supreme
How
Court.
do we interpret that order, my lord? If my lord will kindly see the order at the Honorable Supreme Court's order at page 294. The paragraph 23 makes it clear. At the same time, we are conscious of the limits of judicial intervention. The High Court, in its impugned judgment, permitted reopening of all concluded acquisitions under the 1947 regulation for the assessment of compensation. Such an approach, in our considered opinion, may travel beyond the permissible bounds. Finality of administrative action cannot be lightly unsettled. To do so would not only destabilize public projects but also create physical uncertainty. Balance must therefore be struck by ensuring that that pending and future acquisitions are aligned with the standards of 2013 Act, while leaving untouched those transactions where compensation has been finally determined and accepted. Where compensation was finally determined and accepted. Then
No, that's all right, Mr. Ratan.
paragraph.
We cannot read this paragraph in isolation.
Yes, ma'am.
It has to be read together with
yes, paragraph
28.
28.
Yes.
My lord will kindly say, note in respect of concluded acquisition, what it says, concluded acquisition, where compensation has been finally determined, accepted, and disbursed. In respect of concluded acquisitions, what it says, where compensation has been finally determined, accepted, and disbursed, no reopening shall be permissible. The impugned judgment of the High Court is therefore set aside to that extent. extent. However, in all such matters which remain pending either before the competent authority or before a court
Mm.
/ tribunal, the compensation shall be recomputed, including solution and interest as above.
Mm.
Where, my lord, where the persons have not accepted the compensation, where it has not been determined, and it is still pending, that we have to be paid solution.
Mm.
Still pending, the quantum is still disputed.
Mm.
In those cases, the solution can be granted.
No. In that line, that has not been incorporated. However,
Yes.
you come from the sentence, however,
Yes.
come to the sentence, however,
However,
in all
all
matters.
matters which remain pending,
Mm.
either before the competent authority, meaning thereby the authority, the reference authority or the reference before the this deputy commissioner or the authority
Mm.
constituted under LARA, where the quantum is pending, or if it is the before even the High Court saying that we are required to give the have the solution. We are entitled for solution. If that is pending, then this will be applicable. But prior to that, it should not be a case where the compensation has been already determined, accepted and disbursed.
Mm.
Before it has been disbursed, this should have been.
No, this sentence does not mean that.
My interpretation and is that otherwise the very observation of the
No, that's all right. If on the date of pronouncement of this judgment by this court, no, by Supreme Court, there is no case pending before any tribunal or any court or any authority, then the matter would have been different. Here, the petition is pending before this court.
my lord, that pending.
Mm.
First, it is pending, but it says that we were already concluded.
No, in the case of
word
Mihin
concluded-
Laling also, the process has been completed. So but the amount has been paid. They have accepted it.
Yes,
And thereafter, they have filed a writ petition before this court.
yes.
Then this court has directed that you first exercise the remedy available under the Act. Thereafter, they have filed an appeal before the governor.
Governor.
Governor has dismissed the same. Thereafter, they have challenged that order before this court.
Yes.
And then setting aside that order, the solicium and interest was granted to them.
Yes. Now,
There also the process was concluded.
concluded.
They have accepted the compensation amount.
Yes. Therefore, in this also,
Mm.
but even if this has been upheld, they are not getting the compensation
Mm.
because they were also already concluded.
Mm.
They are Mihin Laling also. They have not. They have won the case, but since it has been concluded,
Mm.
the judicial principle, the law has, my lord's judgment has been upheld, but benefit has not gone to them
Mm.
because it was concluded.
Mm.
Even Mihin Laling case.
Mm.
That is the. Therefore, these are cases subsequently filed. Even in Mihin Laling, they did not get the benefit.
Mm.
And these are cases prior to Mihin Laling's.
They have not been given the benefit.
No benefit.
Okay. Yes, Mr. Koyan.
My lord, as I've said earlier, Mihin Laling case and the instant case is quite similar because in Mihin Laling's case, after taking compensation, when solution was not paid to him, then he approached before the court. And this court has passed an order that Mihin Laling is entitled to get solution with interest, my lord.
Mm.
And it was challenged before the division bench. Division bench has also made similar observation that Mihin Laling is entitled to get solution with interest. Of course, there was some kind of interpretation regarding reopening. That part has been set aside by the Supreme Court, only that part. And my lord, as your lordship has clearly understood this para 28, it says, however, it has certain meaning, my lord. In the earlier part of the judgment, discussion has been made that reopening cannot be made. That is correct. But however means, after however, it says, it's very clear that all matters which remain pending either before competent authority or before the court tribunal, the compensation shall be recomputed to include solatium and interest as above. This is all for those cases who have received compensation but not received solatium. This is for all of them. My lord, the learned single judge also understood that if the matter is pending before the authority, they are entitled. Half of the sentence has been used. Let me see para.
No, you have already pointed it out.
Yes, my lord. If she had read all the complete sentence and applied the whole sentence, then the judgment would have been different. It would have been in my favor, my lord. So I'm entitled to get solatium with interest as per this judgment, because this judgment squarely covers my case, my lord. Under what circumstances this paragraph has been made? My lord, there, as per the appellants, so many pending cases were there in the High Court. That has been reported before the Supreme Court. I was present in the Supreme Court. And we have also filed one petition. Biri Poshi has filed one petition for impleadment to get the matter disposed of as early as possible, because the High Court has passed an order in Biri Poshi's case, here in this case also, that the matter be listed after disposal of the Supreme Court, SLP. So we thought that if the matter is pending for a long time in the Supreme Court, then our matter will also remain pending for a long time. So for implement, we have filed an application. But before disposal of the implement, the matter was disposed of, my lord. But the Supreme Court was well aware of the fact that there are many cases which are pending before the High Court. So this paragraph has been included in the judgment, my lord. This is all about the case.
But, sorry, my lord, I may not have properly explained. My lord, in para 28, the first sentence, it starts that for those concluded acquisitions. Those concluded acquisitions wherein the compensation has been determined, accepted, and disbursed. This reopening will not be permissible. But those matters, other cases where it is pending before the tribunal, authority, or courts, reopening and solution shall be paid. My lord, first condition is that it should not have been a concluded acquisition process. They should not have volunteered. Even if they have accepted, they under protest, and then they are agitating that we are not happy with this compensation amount, and they have already filed immediately, and they have protested. That will be considered not a concluded, because the very fact that they have not accepted this compensation, we have not been paid solution, so we are not happy with this. In the protest itself, before the authority who is going to, and either they approach the authority, approach the tribunal, or the court, that we are not satisfied with this quantum. In that cases, it will be said that it will be unconcluded, so pending. But when they have already accepted, they were happy. Just because this honorable court has given a direction that they are entitled for solution also 100%. Then they come rushing. They come rushing, said, we were also deprived, That is a concluded, that was a concluded acquisition process. For this instant case also, 2013, 14, compensation were disbursed, they accepted. 2023, they give a notice that as per Mihin Laling's case, we also were not given the solution of 100%. So we are also eligible, and we also should be given. That after the conclusion of that earlier, after many years, after several years, they come up, after 7-8 years, they come up and said that we were also deprived of that 100% solution. That cannot be allowed. That is what I respectfully.
No, that's all right. The first sentence of the paragraph number 28 is very much clear.
Yes.
But this second sentence,
Yes. If it is not a concluded one, and they have agitated it.
no,
Just a minute.
that word concluded has not been incorporated in the second
Second
sentence.
sentence.
Okay. Just
When it is
in your case, Land Council for the appellant, in your case, whether the compensation was already determined,
Yes, my lord.
okay, it was accepted
Yes, my lord.
and also dispersed, you have received.
Yes, my lord.
Okay, then tell us how it is not covered under this determined, accepted and dispersed.
My lord, that part is there, but as your lordship has,
Because last part, the last part, however part is only to the extent that it was undetermined, it was unaccepted, it was not yet dispersed.
Yes, my lord. Let me say.
So how it is not covered?
Let me
Your
say, my
case.
lord. As your lordship has already observed, but we cannot read it in isolation with the para 28. There is a clear observation by the Supreme Court that if the matter is not pending before the any competent authority, tribunal or court, that will not be entitled to get solution. But there is also observation of the Supreme Court. However, these sentences are for those cases which are pending before the authority, before the court and the tribunal, my lord. So we cannot read it in isolation. This is
No.
concluding part. my
Yes,
lord.
yes.
This is
Let
concluding
us try
part.
to understand after, however.
Hmm.
So this, what I understand is meant that it was not yet finally determined, it was not yet accepted, and it was not yet disbursed.
Yes.
That in that case, this will cover.
My lord.
In the case where it was already determined, where it was already accepted, and where disbursed and accepted, the first sentence will apply.
No, my lord. That is a wrong interpretation, my lord. See, my lord, the purpose of this paragraph your lordship has pointed out, it is just to prevent future cases after disposal of the matter in the Supreme Court. That is 16 September 2025.
Then you have to come.
From that onwards,
Then again, you have to read
just a second, my lord.
para 23.
From that onwards,
Hmm.
whoever filed before this court or any tribunal or before any authority, they may not be entitled to get solution with interest. But there is a clear line. The cases which are pending before the pronouncement of judgment in a Supreme Court, they are entitled. This talks about that matter, my lord. Para 28. This is very clear, my lord. There is no ambiguity at all, no confusion.
You have to again read. We have to read
Now
again.
that
and
part-
understand para 23 also.
Now, that part I understood. We have to read both the paragraphs. We cannot read it in isolation. Moreover, para 28 is concluding part, my lord. This is concluding part, my lord.
Yes.
We have to pay more importance than other paragraphs than this paragraph 28. This is more important than other paragraphs. So I am saying that, my lord, this case squarely covers my case, my lord. I am entitled to get solution with interest, my lord, as per this judgment. Very clear, my lord.
Yes, Mr. Sakya.
My lord, just one
Yes,
document, page
let-
62.
let
Only
Mr.
one
Sakya.
document. I'll show only one document.
Ah.
Page 62. Page 65, my lord.
Yes,
This is to the
notice
deputy
in the year 2023.
2023.
Oh, you have already submitted this?
Yes, that also why, how they are saying that my, in the second paragraph, in the first paragraph, he says that he have received. In the second paragraph, that my client is entitled for payment of solution for compulsory acquisition of land at the rate of 100% compensation amount as provided under, but my client has not been paid solution at the same, at the time of payment of compensation. In a similarly situated circumstances of the case, the Honorable Guwahati High Court so-and-so has passed a common judgment order dated so-and-so in Mihin Laling so-and-so, wherein direction has been given to the respondents to pay solution and interest to the petitioner. In the circumstance so-and-so, I would like you to request to pay SI ad valorem amount with interest to my client. This is only because my lord has passed an order that their solution will be entitled. That only after your lordship's order, they have started, it was already concluded. Now, how can this?
No, that is understood. But the question is the second sentence of the paragraph number 28 of the Supreme Court. However,
If had it been, that's why, had it been a case where they were not satisfied with the compensation, they have not accepted, even if accepted that no, we are entitled for compensation. If that was pending, either before a tribunal, before a court, or before an authority, then those cases would have been. But here already, they themselves is saying that they are claiming on the basis of the Mihin Laling case.
they have filed a writ petition having not been satisfied with the award
No,
given
my
to
lord.
them.
Earlier, they were satisfied. That is the difference. They were satisfied earlier. They have filed this writ petition because in a similar case, since this honorable court has directed in other cases to pay solicium, now they are also claiming. It is not that they were not satisfied earlier. They have never came before any court saying that we were not paid 100% solution. It is only for the reason that this honorable court has given a direction to pay 100% solution. We were also deprived, so now we are coming.
Mr. Soikia, you are appearing for?
My lord, PWD, my lord, highway, my lord.
PWD highway.
I hear, my lord, I fully concur with the submission made by Mr. Rathar. And also, my lord, whether my lord, view expressed by my lord, Justice Habu, my lord, this paragraph 28 has to be read with, my lord, paragraph 23 of the judgment of the Supreme Court, my lord. My lord, the last paragraph, my lord, where my lord, last writer, my lord is querying, my lord, is that, my lord. Now, my lord, will consider, my lord, who can file a my lord, writ petition or a reference application after, my lord, the award has been passed, the compensation has been passed, or award has been passed. That, my lord, only by a person, my lord, who has not accepted the, my lord, the compensation, my lord, or, my lord, by a person, my lord, who has accepted the compensation but with a protest, my lord. He can only approach the, my lord, appropriate forum to seek the, my lord, grievances, my lord, for enhancement of the compensation, my lord. In this, the facts are clear, my lord. Admittedly, my lord, the compensation was, my lord, paid to them, my lord, and it's a concluded proceeding, my lord, and he has happily accepted the compensation also, my lord. Against which, my lord, they have not preferred any, my lord, reference, my lord, or agitated, my lord, before the collector or the deputy commissioner, or filed a reference before the reference authority, either before the district judge or the authority, my lord. Now, another fact is also very clear, my lord. They have issued, my lord, legal notice to the, my lord, authority seeking, my lord, solicium and interest, my lord, on the basis of, my lord, after the, my lord, disposal of the Mihin Laling case, my lord. They are basically a fence sitter, my lord.
How?
But they have been waiting, my lord. Only after the judgment of the Mihin Laling, they have woken up, my lord. Seeking that benefits, my lord. So, my lord, once the my learner singular interpreted in this way, my lord, upholding the my lord, denial of the compensation, my lord, solicitation and the interest, my lord, in view of the Supreme Court order, my lord, there, my lord, they at the liberty, my lord, before the Supreme Court to seek a clarification from the Supreme Court itself, my lord, instead of approaching filing appeal, my lord, because no irregularity has been committed by learner single bench, my lord, judge, my lord.
No, that's all right, but it appears that the second sentence has not been taken care of.
No, my lord,
There
that's
was
why,
no
my lord,
reference in the judgment also.
from the admitted fact, my lord, they have accepted the compensation, my lord, and no, my lord, protest application has been filed, my lord, before the deputy commissioner also, my lord. This can be reflected from the legal notice itself, my lord,
Mm.
where they said that, my lord, they are also entitled for solicitation and interest in view of the judgment passed by in Mohin Lalin case, my lord.
Mm. Okay, Mr. Kato?
During the read, Malad, the postings also, Malad.
Mm.
This was the submission, in fact, we made before the learned single bench, Malad.
Mm.
Malad, we have to understand the very fact of the case in this matter, Malad. Malad, what happened? Notification was issued,
Mm.
determination was done, and the amount was disbursed, and happily they accepted.
Mm.
Thereafter, Malad, matter ends there, Malad.
Mm.
Then, by your lordship's order,
Mm.
as they referred in Mehin Laling case, Malad, there was a Malad, the order passed by your lordship, wherein the Malad, the solicitation as well as the interest
Mm.
part has to be paid also to the Malad. But that was not in respect of Malad, for retrospective even effect, Malad.
Mm.
Then, Malad, after the judgment came in the Mehin Laling case by your lordship, Malad, all of them rushed to this honorable court
Mm.
for payment of the Malad, the interest as well as solicitation.
That's all right. There is no dispute about
Malad,
it.
Malad, the fact is very relevant. After that, Malad, there was series of Malad, the appeal
Mm.
by the Malad state government as well as national highways, the highway,
Mm.
NHIDCL, Malad.
Mm.
Thereafter, Malad, the matter again went to the Honorable Supreme Court. The Honorable Supreme Court has laid this particular judgment, wherein Malad is rightly pointed out, Malad, to qualify for this interpretation, Malad, three tests has to be passed, Malad.
Mm.
One is Malad, determination.
Mm.
Second is accepted.
Mm.
And third is disbursed, Malad.
Mm.
Once everything has been done, Malad, that cannot be reopened, Malad.
Mm.
That is the interpretation, Malad, here.
Mm.
Had in the case then, if they are not agree with the determination,
Mm.
even Malad, the concluded accusation,
Mm.
even determination, even Malad, accepted.
No, Mr. Kato, you see, there are some decision of the Supreme Court also
Malad,
that filing of the writ petition before the court.
Malad.
That also shows that he is not satisfied with the award given by the authority.
Then, Malad, in that case, Malad,
Mm.
if they are not happy with the Malad, the determination,
Mm.
accusation process,
Mm.
then there is a Malad, of course, another procedures, Malad, Section 64 of the Right to Fair Compensation Act, Malad.
Mm.
Malad, it is not the case of the appellant here in Malad.
Mm.
Malad, if they are not agree with the Malad, the determination, even accepted, even disbursement, then Malad, even
No,
Malad, disbursement is received, amount is received with protest, Malad, even in that case.
there is no dispute about it.
Malad.
In the year 2013, they have received the amount.
Yes, Malad.
They have not disputed
Malad,
it.
once received, matter ends there.
Now, we are concerned with only the pending cases before the court or tribunal.
Malad, pendency is, we have to, Malad, look into, Malad. Pendency is not in respect of, Malad, the determination,
Mm.
not in respect of the acceptance.
Mm.
Pendency is not, Malad, Malad, related to the disbursement, Malad. Pendency is
No,
only,
in respect of determination, because solicitation and interest was not included in the award.
Malad, if they have not accepted,
Mm.
disbursement is not done. Malad, my respectful understanding of the this interpretation is, this is applicable, Malad. Second limb of this order is applicable, Malad. Once, Malad, everything's, Malad, ends, that cannot be reopened, Malad, that cannot be recounted, Malad.
No, there is no doubt about it. Supreme Court decision is very much clear. Paragraph number
Malad.
23.
Malad.
And first sentence of the paragraph number 28.
Yes, my lord.
But we are concerned with the second paragraph.
Second, my lord,
Oh.
second leave of order of the Honorable Supreme Court is very much clear. To that extent, my lord, my respectful understandings of the interpretation is,
Mm.
my lord, once my lord, determination is happily accepted, then received, disbursed, my lord, everything matter is there, my lord. If my lord, they are not satisfied with the determination,
Mm.
acceptance, even my lord, disbursement is not received, received or received, my lord, with protest, then these words qualified, my lord.
Mm.
Petitioner, my lord, entitled for the, my lord, the recalculation of the determined amount, recalculation of the accepted amount, recalculation of the, my lord, disbursement amount, my lord. But here the, my lord, the case is, after everything's matter ends there,
Mm.
finally, my lord, the efforts on the hoping that, my lord, the, yes, will entitle for the, my lord, the solatium and the interest. Subsequently, this writ petition has been filed, my lord. During the pendency of the Mehil Laling case in the Honorable Supreme Court,
Mm.
that, my lord, fact has to be, my lord, ascertained, my lord. Had it been the case that, my lord, if they have not accepted the, my lord, the, in the, my lord, happy with the determination, then, my lord, and the disbursement is not received on protest, my lord,
Okay.
then disqualified, my lord.
Okay.
Much obliged.
Heard Mr. Koyang, learned counsel for the appellant. Mr. Ratan for the respondent number 1, 2, and 3.
1, 2, and 3.
Mr. Soikia for respondent number 4. And Mr. Kato for the respondent number 5.
Five, my lord.
When concluded, judgment reserved.
My lord.
Obliged.
Deep level.
We'll take 5 minutes break.
Item number 21.
क्या करें? PIL, my lord, is pertaining to the study progress of the work, my lord. This Naharlagan section, the lordships yourselves might have seen. This was supposed to be completed on 7th of December 2024. Now, today, my lord, there have been subsequent developments. This honorable court has granted liberty to the government to take actions as per law. I believe the contractor, my lord, they have now filed the IA, my lord.
For
Mr. Dubey, my lord.
Lordship would take up IS 67. Lord. On 10th of this month, Lord, there was notice was issued to the respondent.
Lumibana ako po. Paano hanggang? Pinila.
on Chennai
Ano ka objection?
तो फाइल किया
Art.
नहीं दिया ना
पूरा करो उसका action. आराम से बोलेंगे.
Today, the opposite party has to make their response. You are the opposite party, yes?
My lord, I have filed this PIL as a resident of this area. Now the termination is not my concern. It is with the department who will do it. It is a fight between these two, the private as the contractor and the. I have brought it to your lordship's notice the lack of progress in the work. Whether to terminate or not, that is the decision of the government, my lord. It is not for me to say. The government will have to contest. Termination notice should, I believe, by them. We have no.
If I be given just a few minutes. But just factual backgrounds of this case. This contract, the tender and all were plotted in the year 2021. Work was supposed to start in 2021. And the deadline for completion of the work was 7th of December 2024. Prior to the 7th of December 2024, this PIL was filed in the month of July. In 2024 July, this PIL was filed. And when the PIL was filed, the remaining period for completion of this work was just 6 months something. 5 months. 5 months remaining. And in 7th of December 2024, it couldn't be completed. Now, the contractor, they asked for extension of time. So, we had given an extension of time from up to 31st of July 2026, 18 months extension of time.
31st of July 2026.
So, in between, they were supposed to make up all the deficits which they couldn't do, and they should have to complete it by 31st of December 2026, 31st of July. Now, while doing this, there are certain milestones to be achieved in every month. 4 months, 6 months, there are certain milestones to be achieved. Now, by the progress of the work, the present progress of the work, it has become impossible for the contractor to complete it in the given time line, up to 31st.
Within 31st of July 2026.
Pilot has seen the nature of work and work in progress. Nothing. So it has become impossible. Admittedly impossible. So if my lord kindly see the order dated 11 February 2026. This is also annexed in the IA at page 38.
Page number?
38.
That's at 36, your lordship would find at page 38 in the IM lot. Because the other case record is very bulky, my lord. Your lordship would kindly have a look at the
IA.
Yes.
In the third paragraph, my lord. Oh, 1, 2, 3, 4, 5, fifth paragraph. On a specific query made to the learned counsel for the department along with the officer who is present, as well as Sri R. Dubey, learned counsel for the respondent number 7, a response have been given which would be practically impossible to complete the work by the extended deadline on 31/7/2026. This was when the dishonorable court had asked that whether you will be able to complete the work by 31st. They admitted that this has become practically impossible. Now, since we cannot wait up to 31st of July, even waiting up to 31st of July also they will not be able to complete the work. So why not we take action right now? We have given them an intention to terminate the notice. This honorable court also in the next paragraph, taking into consideration the aforesaid facts and circumstances of the importance of the matter, which has got immense public importance, this court is of the opinion that the department be given a liberty to take all steps, further steps for timely completion of the work by ensuring that the standards are maintained. Meaning thereby we are given, because either by this contractor or by any other contractor, timely completion of the work we are required to, as a department has been given the liberty for timely to take any action against them and to get the work done even by another, by terminating and appointing another contractor. Now we have given them the intention to terminate. This order has been further extended in the subsequent order also, that the liberty, the earlier liberty is still remains. Now this IA has been filed saying that we may be given time, extension of time, whether this can be maintainable. This would, they are seeking time up to 31st of July to carry out the work. This, when it has become impossible, they are not doing nothing. Why will the department be bound to wait till then? And this prayer itself is against the direction given by this honorable court. It will, if any order pass allowing this IA, giving extension of time, that would be a review of this order, earlier orders of this honorable court. That will amount to review. What their prayer is, my lord will kindly see in the prayer in this ayah. At page 22.
Got it.
In the premises aforesaid, the applicant respondent of the above name most respectfully prays before your honorable court to admit the application, and after hearing it, please to restrain the respondent PWDs from proceeding further to terminate the contract as per notice dated so and so, and allow the applicant respondent time till 31st July to achieve the work program as indicated above, which they have themselves said that admitted before this honorable court that it has become impossible for them to complete.
So what purpose will be served by giving you further time
Yes, exactly.
till 31st of July 2026, Mr. Dubey?
Yes, please. I'll respond to it. My lord has seen the order dated 11/2. For my satisfaction, your lordship would kindly have a look at it again, my lord. Page 38 of the I.
Yes.
I'm reading from para 4, my lord. This matter has come up for numerous occasions, and this court, while an order dated 24/12/25 had recorded that the work has to be completed within 31/7/26, beyond which no extension is required to be given, my lord. I will kindly mark this. It may be mentioned that the scheduled date of completion was 7/12/24. And from that day, more than a year has passed. On a specific query made to the learned counsel for the department, along with the officer who is present, as well as Sri so-and-so, learned counsel for response has been given, which would practically impossible to complete the work by the extended deadline of 31/7/2026. Taking into consideration of the efforts and the importance of the matter, which has got immense public interest, this court is the opinion that the department be given liberty to take all further steps for timely completion of the work by ensuring that standards are maintained. Now, my lord, kindly have a look at order dated 24/12 for a moment, which starts at page 25.
Yes.
I'll not bother your lordship with the entire order. Your lordship can come to page 29. After taking note of Millard, your lordships led by Justice Uti Hadrung Millard has passed this order, Millard. Millard, certain directions were given, Millard. This has in fact not been complied with, or part of it is being still carried out. My lord, kindly come to next page. Roman 8. Further, no extension beyond 3726 shall be granted as a matter of course. So, my lord, your lordships in this present list is determining the progress of the work. What has happened is, my lord, it's fact. My lord, your lordship would also consider that I am also a party respondent herein. Your lordship is looking into the perspective of public interest. There's no dispute as regard, my lord. And my lord, when query was put to me, my lord, and to the contractor, my lord, we could not have said, which is not possible, saying that we will complete by 31/7. My lord, at the same very time, your lordship would also see the contract in question. My lord, they had extension my timeline because there is a stipulation in the contract which says that 90% of hindrance-free land would be given, which would start the appointed date. Look, that we had got on 17/10/2025. There was a revised plan so far as flyover work is concerned, because it consists of two things, Lord. From that, there is a communication from the Ministry of Transport, my lord. There is a circular which said if anything is there, my lord, if there the work is there, my lord, party has to give a period of 3 years. Not on 17, they give us the revised, accept my revised proposal as regard the bridge part of it. And on the same very day, they issue notice of curing. But this is one aspect of the matter which is contractual in nature, my lord. Lordship has said that you are not a petitioner herein, my lord. But still, my perspective also has to be looked into. My second grievance was, my lord, that, my lord, they have withheld my payment. My lord, if my payment is not released, how I will continue to work, my lord? But the sword is hanging. My lord, after filing my IA, my lord, they have issued me a letter on 2nd or 3rd of March, my lord, I'll place on record, which gives a reason, my lord, why they deducted my amount. They say for extension of time. Part of it say 3 crores odd, my lord, I am entitled to, my lord, even assuming they can deduct it. Now, in that letter, my lord, they say that 87% of the land was given to me, not even 90. And that's why they have extended time to me. It's not extended for my own cause, my lord. My lord, we were made to understand, my lord, by that time, my lord, will be given the entire land.
No.
We progressed. So, my lord, we also have a contractual dispute.
Whatever land was handed over to you, whether you have completed your work in that part.
My lord, so far as timeline is concerned, that is the stipulation.
forget about
So far as
timeline.
whatever we have given, my lord, we have worked on this.
Absolutely not, my lord.
My lord, the
Absolutely.
timeline would have to be counted from the point. Your lordship would also consider. My lord, I am also suffering loss because I am also deploying people, my lord.
We are not sitting as arbitrator here.
My lord, that's why, my lord.
Whether the other respondents have given you payment or not.
My lord, when your lordship would look into it, my lord, the payment is also an important consideration for which my lord work would be dependent upon, my lord. My lord, your lordship would kindly consider. There is a threat on me that my contract will be terminated. My payments are stuck up. I have a pending bill of around 16 crores, my lord. Last updated on 12/3. No payment is being made, my lord. Let them show, my lord, whether they have made me a payment or not. That's why, my lord, your lordship was pleased to issue notice to them, my lord.
That is not your writ petition we are to deal with here.
No, my lord. I'm not.
This is a
my lord, I am not
PIL
calling.
list.
No. Yes, I understand, my lord. But my perspective also has to be looked into, my lord. Your lordship would kindly have a look at order dated 22/1, my lord. Page 33.
Yes.
My lord, we have indicated our reasons, my lord, at para 3, your lordship would see as regard the payment. And there was a direction by your lordships also, my lord, to look into this matter. So it's not that your lordship has not taken note of, my lord, my grievance also. My lord, my consideration before your lordship is, my lord, there is a direction to the department that you expedite everything. My lord, the test is whether terminating me, my lord, encashing my bank guarantee, terminating my contract, will that serve the, my lord, public interest in question, my lord, whether, my lord, in the circumstances under the contract I am entitled for extension.
From the pace of work
My lord,
you have been executing since the date of allotment,
My lord.
it will take another 5 to 6 years
Yes, my lord. Maybe more.
to complete the process.
my lord,
Can we allow this?
but my responsible submission would be, my lord, under the contract, my lord, I have got certain rights, my lords, which I have also
No, we
agitated.
are not supposed to determine your
No, no.
rights here.
My lord, I have a remedy.
Your writ petition.
No, it's not my writ petition.
Yes.
But at the same very time, my lord, I am also a party to this proceeding, my lord.
I dismiss.
My lord had called for a response from them, my lord.
No.
Highly obliged.
We'll list the matter next, but
After two. Can it be on 6th, my lord?
6th of April.
My lord.
It is Monday, Lordship. 6th of April is Monday.
6th is holiday.
7.
7th.
7th.
7th of April. Okay.
August.
Item number 22.
Deeply, my lord.
May it please your lordship. My lord, this is a jail appeal, my lord. And on last occasion, this honorable court was pleased to appoint a legal aid counsel, my lord, on behalf of the appellant. And my lord, he has telephonically informed me that today he has some difficulty to come before this honorable court. The counsel who has been appointed by this honorable court, my lord. Your lordship will find the last order on.
Mr. Ite,
Yes, my lord.
you see, this order was passed on 21st of May 2025,
Yes, my lord.
right?
Yes, my lord.
Since then, the matter was not listed before this court.
Yes, my lord.
And furthermore, the legal aid counsel
Yes.
who was engaged here,
Yes, my lord.
he has not filed any memo of appeal.
Yes, my lord. And condemnation of delay also, my lord. There is a delay. Yes, my lord. As on that, he has not filed.
So why should we not terminate his appointment in this matter and we will engage someone else?
Yes, my lord. That is up to your lordship, my lord.
You suggest a name who is irregular in the court?
Legal aid from the list, my lord. The list is there, my lord. For legal aid counsel. Yes. My lord, so far as the list is concerned, my lord, Ubor is there, my lord, in the legal aid council. He may be appointed. Ubor, Uttam Bor, yes.
He is irregular?
Yes, my lord.
Okay. Heard, Mr. Ite, learned additional PP for the state respondent. No, for the learned additional PP for the respondent. Mr. Ite submits that in this matter, Mr. Zez Zini was appointed as a legal aid counsel by this court by order dated 21st of May 2025. But Mr. Zini has some inconvenience today, and therefore he requested Mr. Ite to take an adjournment. However, it appears that this matter was first listed before this court on 21st of May 2025, appointing Mr. Zini as a learned legal aid counsel. But till date, neither application for condonation of delay nor the memo of appeal has been prepared and filed. And in that view of the matter, this court is inclined to engage Mr. Uttam Bori
Yes, my lord.
as the legal aid counsel. Relieving Mr. Zini from the assignment. The rest itself furnish the relevant judgment and also other papers to Mr. Bori within a period of 2 working days from today, and also reflect his name in the cause title. List the matter on next Tuesday.
Okay, madam. Obliged, madam.
Item number 23.
Lordship,
Yes.
I have been aggrieved by an order passed by the Additional Deputy Commissioner Likabali, wherein a deviation of 3 kilometers is passing through my private land where I have cultivated orange orchard, and it's my livelihood, Your Lordship. And for that, challenging the order of the Additional Deputy
There is
Commissioner,
a delay of
delay of 220
9 days.
Yes, Lordship.
Okay, let notice go.
Yes, notice. Otherwise, delay also reason is not explained properly.
Earlier, Lordship, the case was handled by another advocate. The counsel was different, and I'm unaware of the delay. That's why.
Heard, Mr.
Titatak.
Learned counsel for the applicant, and Mr. Jitara, learned counsel, standing counsel for the respondent number
1.
Respondent number 1. Madam Songita for 2. Respondent number 2.
I am 1, 3, 1 and 3, I think.
1 and 3. 1 and 3. This interlocutory application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 229 days in preferring connected writ appeal against the impugn judgment and order dated 26/6/2025 passed by a learned single judge of this court in WPC number 475 of 2023. Let notice be issued to the opposite party, returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1, 2, and 3 since they are represented by their standing counsel. But extra requisite copy of the petition application will be furnished to them during the course of the day. Step upon respondent number 4, 5, opposite party number 4, 5, 6, and 7 be taken by speed post and also by usual process within a week from today, list after 4 weeks.
Always.
Deeply obliged.
Next item.
Item number 24 and 25.
May it please your lordships. Lordship, I'm appearing in item number 24, lordship. Lordship, in this case, I have been engaged in this case day before yesterday, and therefore I have filed a fresh wakalat number today. Lordship, therefore my name is not listed there, and perhaps the wakalatnama is also not tagged with the original with the court records. If I may be allowed, lordship, I can start with my arguments, or lordship, on any other date I can start the argument. Lordship, in that case, any date after 9th of April, lordship? Any specific date?
23rd of April.
23rd of April, lordship.
23rd April, your lordship.
Okay, heard, Mr.
Dr. P.P. Medhi, lordship.
Dr. P.P.
Medhi, lordship.
Learned Counsel for the appellant. And Mr. Nebo for
Complainant side, complainant victim side.
Respondent number 1 in item 24.
Learned Counsel for the respondent number 1. And Ms. Jenny for
For the state, your lordship.
learned additional PP for the respondent number
1.
Respondent number 1. Respondent number 1. Mr. Medhi submits that he is engaged in this matter day before yesterday,
Lordship.
and he has filed his wakalatnama today.
Lordship.
Today, and he prays for listing the matter on
23rd of April, lordship.
3rd of April. The pair having not been opposed by Ms. Zini and also by Mr. Nebo, the matter stands adjourned. This to be listed on 23rd of April.
25. no?
25 May.
Okay, okay. Recessor list the matter without one of us,
Oh.
namely within bracket Mr. Bodhi Abang.
Lordship, he is appearing for 25, lordship.
You are for appellant. Amicus. Heard, Mr. Learned. Amicus Curiae for the appellant and Mr. Nebo is here.
For complainant.
Yes.
Mr.
Yes,
Nebo
yes.
and Ms. Zainab for the respondent number 1 and 2. 1 and 2. So against the same judgment, this 2 appeals are preferred.
Yes, lordship.
Yes.
Okay.
Connected.
SSL lists the matter along with item number 24 on 23rd of April for hearing.
Deeply.
Most obliged.
Over.
Yes. Judgment of principal seat item number 1.
So there was one list of names of government. What is there? Petition allowed. Impugn order dated 27/5/2025 stands set aside and quashed. Yes.
Wait, I want to mention pending matter is this may be taken up on day after tomorrow, my lord.
Day after tomorrow, there is a division bench.
And on my lord, on
That will be
20,
on Friday.
on Friday at 10,
Friday?
20.
Okay.
Well, at item 12, it was a IA for a review petition. Same today's like today's Mihin Laling case was pending, therefore this review was sought. But now this has become infructuous now.
Okay.
In fact, here the same case, here the petitioner filed two cases, two writ petitions simultaneously, one for releasing the payment and at the same time for payment of 100% solution. That first writ petition for releasing the payment was done, the 100% solution was pending because that was before accepting that payment, his case was pending already. So his case will be covered.
No, who filed this IA?
We filed saying that the Mihin Laling case has not been dismissed, that is still pending.
Okay.
So we sought a review of this honorable court's
Now this IA become infructuous.
IA as well as the review petition has become infructuous.
Okay. Mr. Ratan, learned additional advocate general for the applicant and also for the review petitioner submits that this IA and also the review petition become infructuous and the same may be closed.
Yes.
Accordingly, taking note of the submission of Mr. Ratan, learned additional advocate general, this IA stands, IA and the review petition stands closed.
Yes, highly obliged.
May I please, Lordship? Lordship, item number 10, Lordship. This transfer matter, I'm for the petitioner. Today, the respondent department is supposed to file their affidavit, but yet not. So, matter may be listed after 2 weeks.
After 2 weeks. Mr. K. Lowland, learned counsel for the petitioner. Heard Mr. K. Lowland, learned counsel for the petitioner, and Mr. Z. Tarak, learned standing counsel for the
RWD.
urban,
RWD, Rural Work Department.
rural,
Rural Work Department.
Are there?
and Ms. Sangita for not here. ZA is government.
One. Respondent number.
Okay.
225.
225. Mr. Lowland, learned counsel for the petitioner submits that though the learned standing counsel for the rural work department is supposed to file the affidavit in opposition, the same has not yet been filed. And as such, he pressed for listing the matter after
2
2 weeks. After 2 weeks. Where allowed, recess and list the matter after 2 weeks.
And Lordship, there is an interim order, definitely.
Interim order passed earlier, shall continue.
Deeply obliged.
Lordship, I beg to mention item number 8. With the
Yes.
consent, yes, with the consent of other side, Lordship, this item may kindly be fixed on 30, Lordship, on 30 of this month.
Who is for the petitioner?
Mr. D. Pangin is there. I have taken the consent first.
Okay.
I'm for the petitioner.
Petitioner. Mr. Your name, please.
Sita Jo. Appearing on behalf of Deepangi.
Also heard Sangita, learned government advocate. The state respondent, Ms. Sangita submits that. What is the ground for adjournment?
Lordship, there is some difficulty today, Lordship.
You have already filed your affidavit?
Yes, Lord, pleadings are complete, Lordship.
Submits that. She has some difficulties today to argue the matter and place for listing the matter after
On 30, Lordship, 30 of this month.
30th of this month. Where allowed.
Apply.
Item number 1. My lord, may I?
Yes.
My lord, in respect of the cases like this, now Department of the PWD has a without
Today, Mr. Tapin is supposed to obtain instruction.
Yes, absolutely.
Whether instruction is available.
Yes, Lord. Lordship, issue is pertaining to constructions of protection wall, Lordship.
Mm.
The part of the road already, Lordship, due to landslide, it fall down, Lordship.
Mm.
Now traffic is already stopped in this particular road stage since last 1 year, July 2025, Lordship.
Mm.
And Lordship, see the kindly come to this. I just that orange one, the first orange plaque.
Yes.
This is a photograph, Lordship.
Yes.
Lordship can see the the second photo down below, Lordship.
Mm.
This is the Lordship. This is steep slope, Lordship. Just we want to, Lordship, construct, Lordship, protection wall on the side of this road, so that this road can be, Lordship, reconstructed again, Lordship.
Okay.
Now, if Lordship turn to next page also, Lordship can see the road, Lordship, down below, nothing is there, Lordship. Very steep slope, Lordship.
Mm.
We have sanctioned crore amount to construct the protection wall.
Mm.
So this is the, Lordship, the physical status.
Mm.
And that apart, Lordship can see, Lordship, just one, that yellow plaque I have, that is notifications of 2006.
Mm.
Here, Lordship will find this notification. It indicates the, Lordship, the wide of the road, Lordship.
Mm.
And so far this particular road is concerned at serial number 11, Lordship.
Mm.
Road connecting Ganga Market to Papunala via Julie Blaze, Lordship. This is a kind of bypass road to this Itanagar Nahalagan road, Lordship.
Mm.
And this wide is 24 meters, Lordship.
Mm.
Lordship can see the wide of the road.
Mm.
And if, Lordship, it compare this very these details with the photograph, Lordship,
Mm.
hardly of this 5 meters road only, Lordship.
Mm.
Now the notified area is 25 meters in wide, Lordship.
Mm.
And I have spoken to the authority, and the authority said that to some extent, Lordship, some area is being touched to the lane of the petitioner, Lordship.
Mm.
But that is in the interest of the petitioner's lane only, Lordship. Because we are only protecting the road only, Lordship.
Mm.
And he is asking for a compensation, Lordship. And on this, on that aspect, Lordship,
Mm.
the complaint was lodged before the authority,
Mm.
and even hearing was done.
Mm.
And as per the hearing, Ish.
Last bill. मेरे पिताजी को करनी है।
Mm. Yes, it's hearing.
इसी का ये पेज 18 1 exactly. इसी का ये पेज 124.
124. The hearing was done, and the petitioner, he could not, Lordship, show or anything, any document or any evidence to show that this land belongs to him, Lordship. So therefore, accordingly, his compensation has been, a claim has been
Okay.
rejected, Lordship. Now, this particular, Lordship, page 24, 124,
Mm.
this is not under challenge, Lordship, because by this order, the concerned magistrate has, Lordship, held that the petitioner failed to prove his case, Lordship.
Mm.
This conclusion has not been challenged in the present writ petition, Lordship. And that FR lordship, the petitioner is questioning the lordship NIT lordship. The petitioner is stranger to the NIT, the tender process lordship. He is not participating in the tender process lordship. At best, what he can say is that lordship, without compensation, his construction may not be lordship done in his plot. That at best that could be the case of the petitioner lordship. But here he questioning the tender itself lordship.
Okay.
On technical count lordship, I am questioning that lordship.
Okay.
And conclusion of the magistrate, where lordship it has been held that the petitioner failed to prove that this land belongs
So
to.
you have participated in the hearing process?
Yeah, my lord, I was participated in the hearing process, but it was without any, just one telephonic call from the magistrate office or from the DC office. According, I went there, but there is no opportunity given to me to produce of the document. Even no any give a time for the, but this land is belonging from the my ancestral property land, my lord. This is my private, purely private land. So whereas my lord, I was submitted to authority like a chief engineer Western Zone and superintendent of engineer Western Zone and the executive engineer for the acquisition of the land. For the as a good citizens are ready to be donate, or either it may be whatever it may be for the acquisition of land under the Land Acquisition Act. But authority has no any response, my lord. Thereafter, my lord, I was representation submitted before the principal secretaries at the PWD also on 9/3/2029, 26. But representation was not disposed, my lord. Whereas as per the geotech, that my land is total is 22,500, my lord. But almost the 50% land is covered by this construction agency, my lord. So that I'm no way to alternative way. I came to this honorable court for the sake of justice. Whereas, my lord, as per your Land Settlement Act of Section 4 and 5 and 6, not complied by these authorities. Where is actually the duty of that respondent should be instructed to the deputy commissioner of the concerned deputy commissioner for the opting for the acquisition. But if no process was anything done by this authority, my lord. That is totally failure by that undermining by the law or without any acquisition. That is no, there is no any alternative way. My lord, Article 300A of the Constitution. What is the right of my properties? It should be not be
That's all
deprived.
right. First, you have to show your document to establish your right over that property.
Yes, my lord. Actually, this is my property land, ancestral land.
Here you have participated in the hearing process.
Yes, my lord.
Thereafter,
My lord.
the executive magistrate has passed the order.
Yeah.
That order is not under challenge.
My lord, please see that this my annexures of that's my land. Annexures, my lord, see and page 117 is a gift deed. Actually, this gift deed is belong from my fathers and my paternal uncles, where I'm grown up. So that land was gift, it was done in the 2022. In total, it's
Sir, this was a registered document? No.
no, my lord, this is not a registered document.
What is the value of the property?
My lord,
What is the value of that property?
my value of the property is now that is capital regions. It's not more than the 2 crores.
More than 2 crores.
2 crores, my lord. So the total square meter is 150 by length and 150 by.
Whether in view of the Registration Act, this gift deed can be acted upon?
Yeah, my lord, it is actually this is tribal estate, my lord, as per our.
Maybe. Even in case of private estate also, there is a requirement for registration of the deed.
Yes, my lord. But
so whether this unregistered deed will confer any title upon you? or ownership upon you?
My lord, this is totally private land. Even the private land, we have a very innocent of the law also, well awareness of the law also. So I did not register this DTK.
Okay, Mr. Tapin, you bring on record this instruction by
No.
filing a short affidavit.
No, sir.
My lord, that this tender is open, going to be opens on that 19, that is day after tomorrow.
What you have to do with the tender?
Well, I will participate. I will be participated for the tenders, but
You want to participate in the tender?
yes, my lord, I will be participated.
So that is perhaps already over.
Now tender will open on the 19th in the evenings. And
19th of this month?
Yeah, 19th of this month. So that, my lord, this is a statutory law. Without any land acquisitions, as per the section 4 and 5 and 6, this is statutory law, my lord. Then we first take the land acquisition and formalities to legal permission should be obtained from that authorities. Till then, my lord, this
No, the thing is that without participating in the tender process, how can you challenge the NIT? Moreover, this is a infrastructure project.
yes, my lord. My lord,
And in respect of this infrastructure project, there is one bar in granting an injunction also.
So, my lord, that is
Specific relief.
my prayer is that, my lord, very short times, let be directing the authority for the immediately land acquisition. Till then, this order may be, my lord, suspended within the period of 1 month, my lord.
No.
For the without the effect of the development activity, my lord.
Infrastructure project, no stay. And moreover, this page number 124 annexure H. This order was passed after hearing you.
On his complaint only, no. He's a complainant in that. Yeah.
Okay. Heard Mr. P. Bui, learned counsel for the petitioner, Mr. S. Tapin, learned senior government advocate for the state respondent. Person to order dated 12/3/2026, Mr. Tapin has received instruction from the respondent authorities and placed the same before this court. Where is the said instruction? And it is provided that Mr. Tapin shall bring on record the said instruction by filing a short affidavit. List the matter on next Monday.
On 30th.
30th.
30 of this month.
Okay. Let's just list the matter on 30th of this month.
This month. Lordship, notice, in that case, notice may be issued. Lordship.
Notice not issued.
Not yet issued.
Okay.
Short notice may be issued and returnable on 30 of this month. In the meantime, I'll be filing my affidavit.
Issue notice to the respondents, returnable on 30th. However, no formal notice is required to be issued since Mr. Tapin entered appearance for all the respondents.
All the respondents.
However, extra requisite copy of the petition will be furnished to him during the course of the day. List accordingly. Yes, next item.
Obliged.
Item number 2.
Marvelous, my lord. My lord, by this petition, I have a, my lord, limited prayer, praying for disposal of the representation which is pending before the additional deputy commissioner and the tally. Now, my lord, the nutshell of the facts behind the, my lord, filing of the writ petition is that, my lord, I am having the land which is polled within the, my land is polled within the Kamla hydroelectric project to be affected, my lord, to the land affected area. Therefore, my lord, in my land, my lord, there was a land dispute. Other party has come to dispute with me, but that dispute was already settled. My lord, may kindly come to the page number 14, my lord. This is my application praying before the additional deputy commissioner, praying for conducting of the mail. My lord, mail means the customary court, my lord. And this is page number 14. And accordingly, in response to this representation, my lord, the president of the Tally unit, Karadadi Tally unit was, my lord, endorsed to dispose of my case. And accordingly, the mail order was issued. My lord will find in page number 15. Wherein, my lord, this was fixed on, my lord, this was supposed to be held on.
Okay, you have filed one representation.
My lord.
And the
Therefore,
said representation.
yes, my lord,
Now,
yes, my
Mr.
lord.
Modi, the said representation is now to be disposed of.
My lord, that is my
Yes,
prayer, my lord.
Mr.
So
Ratan.
at this instance, my lord, this can be disposed of.
My lord, in fact, it seems there is a land dispute between two parties, the petitioner and some other party. That party also is not made a party here in this writ petition.
Maybe we will only direct
Without
to dispose of the representation.
without entering into the merits.
My lord, without
Otherwise,
entering-
No.
Yes,
This court cannot enter into the merit,
yes, that can be.
but they have to dispose of on merit.
Yes.
The
My lord.
representation.
Exactly, my
Yes. My lord may direct for disposal of the representation
Okay.
without entering into, only with the limited prayer.
Okay.
Yes.
Heard Mr. Modi, learned counsel for the petitioner, Mr. Ratan, learned additional advocate general for the state respondent. In this petition under Article 226 of the Constitution of India, the petitioner has prayed for issuing direction to the respondent authorities
additional deputy commissioner.
especially to the respondent number 2, that is the additional deputy commissioner, Tali, Kadadri district, Arunachal Pradesh, to dispose of the representation dated 5/3/2026 by passing a speaking order upon hearing both the parties. Mr. Modi, learned counsel for the petitioner, submits that the petitioner is having the land within the land affected area of the Kamla hydroelectric project at Tali Circle under Kadadri district. And there was a dispute between the petitioner and the other parties in respect of the said plot of land. Thereafter, the additional deputy commissioner, Tali, has ordered to discuss the matter in the customary court to decide the ownership of the land. And thereafter, a decision was drawn in favor of the petitioner on 22nd of January 2026, declaring the disputed land in favor of the petitioner. And after expiry of the period of appeal, the petitioner herein has approached the ADC Tali for inclusion of his name in the beneficiary list of the said affected project on 5/3/2026. But the same failed to evoke any response from the respondent number 2 till date. And he submits that this writ petition may be disposed of by directing the respondent number 2, the ADC, Tali Kadadri district, to dispose of the representation filed by the petitioner. Dispose of the representation dated 5/3/2026 filed by the petitioner after affording an opportunity of being heard to him and also to pass a speaking order upon the same. Mr. Ratan, learned additional advocate general, submits that he has no objection in the event of directing the respondent number 2 to dispose of the representation filed by the present petitioner without, however, entering into the merit
And
of this petition.
and giving opportunity to all parties. All
Accordingly, taking note of the submission of learned counsel for both the parties, this court is inclined to dispose of this petition by directing the respondent number 2, the ADC Kadadri district, to dispose of the representation dated 5/3/2026 filed by the petitioner after affording an opportunity of being heard to the petitioner, no, to both the parties,
All the parties.
to all the parties, and thereafter to pass speaking order. And the aforesaid exercise has to be carried out within a period of 2 weeks from today. The petitioner shall obtain a certified copy of this order and place the same before the respondent number 2 within a period of 1 week from today.
Item number 3.
May it pleases your lordships.
Yes.
Lordship, the petitioner before your lordship is a holder of a license for running, my lord, weekly markets on 2 days. Lordship will get the license at page 13. But I have the valid license to run the weekly market on Sundays and Tuesdays, my lord. Now, what happened, my lord? It appears that some representation was filed in October 2025, and pursuant thereto, my lord, a meeting was held under the chairmanship of the commissioner, whom my lord lordship gets the minutes at page 26.
Yes.
My lord, as per the minutes, my lord, may I read, my lord? In pursuance of the minutes of the meeting taken by the learned Chief Secretary, Government of Arunachal Pradesh on 28/2, a meeting under the chairmanship of the commissioner, whom was held in his office on 19/2, to discuss about banning the operation of weekly markets held almost every day of the week, resulting in frequent visits of non-local vendors and increased possibility of the entry of unauthorized immigrants to the weekly markets. The Home Department has entrusted to examine the feasibility of restricting the conduct of the weekly markets to a single specified day in a week. As such, the Commissioner Home took a meeting with the following officers to seek their comments on the aforesaid feasibility. And my lord, the last paragraph, it is said that after due deliberation, it was unanimously decided to formally seek comments about the so-and-so, and thereafter the Home Department will examine the same and submit the matter for government decision. Now, after the minutes, my lord, at page 27, an order has been passed that now the markets will operate only on Saturdays. In the middle portion, my lord, therefore, in view of the above, the Government of Arunachal Pradesh hereby designates Saturday as the only day for conducting weekly markets in the Itanagar capital region and Papumpara district. And pursuant thereto, my lord, the DC has issued the order at page 28. I mean, my lord, reiterating that it will be held on only one day, Saturday. And all the weekly markets.
So what wrong with the order?
My lord. Now the first wrong is that, my lord, the order has been issued without hearing us. Now my right to operate the market as given in the license, my lord, for 2 days has been curtailed, my lord, to 1 day without hearing me. Now the ground is that to stop the entry of unauthorized immigrants, my lord. My lord, we whole work support that. Now, how by reducing the number of days from 2 to 1, the government is seeking to achieve this objective, my lord, I feel with utmost respect, my lord, fail to understand. My lord. Because if the government is saying that we are holding the market every day, then that can be restrained, my lord, strictly in accordance with the license. Now, you have given me a license to operate the market for 2 days. From the markets, my lord, the local vendors are earning something, my lord. Now, without issuing,
whether Mr. Dekka, you see whether the issuing authority of the license is not entitled to modify the condition of the license.
It will be, my lord, but subject to hearing me. Once you have given me a license, a right has accrued in my favor. Now, without issuing any, without doing anything, my lord, how can you curtail the license, my lord?
Okay.
And
Yes,
the license
madam.
by the municipal corporation. Lordship had just I'll take 1 minute, my lord. On an earlier occasion, Lordship had the occasion to deal with a similar matter. Lordship finds the order at page 20.
I have seen it. I have seen it. Okay.
That one is Lordship here in this page 27, Lordship. We have not read it all, Lordship. It says, it has been reported that weekly markets are presently being conducted on multiple days of week, resulting in frequent participation of non-local vendors and increasing the possibility of entry of unauthorized immediate, apart from causing major revenue loss to the state government. This is also another reason here, Lordship. And Lordship, 1 day has been allowed already, and it is in the domain of the state to make, Lordship, change and make the decision.
No, that's all right. But here the contention of the petitioner is that without giving any notice, without giving any opportunity of being heard to him, this condition has been modified.
Lordship, for modification, they have been already, they are continuing with 1 day, Lordship. They are
Right.
being allowed earlier in the repetition, the weekly market was suspended, all the weekly markets. That's why this order was passed. And even the license were cancelled, all the licenses were, without hearing the petitioners in that WPC, which has been annexed here. So he cannot, this cannot be
No,
compared.
the license
This
was
is not
granted
at all-
to conduct the market on 2 days.
That's true, Lordship.
But without giving any opportunity of being heard, the condition has been modified to 1 day.
Lordship. Lord, that's what I'm saying, Lordship. It is in the domain of the state, Lordship.
No, maybe
This is the,
you can do it,
yes, Lordship.
but after giving an opportunity of being heard to the petitioner, that was not complied with.
That is there, of course, but then it has not been suspended. He's still running one on Sundays, Lordship, Saturday. Only Tuesday has been suspended, Lordship.
No, maybe,
Not only,
but the condition is violated.
all the markets has been, Lordship, suspended.
Okay.
Not only.
Heard Mr. N. Decker, learned counsel for the petitioner. Ms. Ite, learned additional senior government advocate for the state respondent. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order dated 9/3/2026 by restricting the running of the weekly market. By restricting the market once in a week, that is on Saturday.
Yes, sir.
Saturday. Mr. Decker, learned counsel for the petitioner, submits that the petitioner herein was granted license to run weekly market twice in a week under the banner of MS Sunday Weekly Market and Tuesday Weekly Market located at Sector Colony, Doxo, Zoo Road, Gopur, in Itanagar town, within the jurisdiction of Itanagar Municipal Corporation. But by the impugn order dated 9/3/2026, the running of the aforesaid weekly market was restricted to once in a week, that is on Saturday. And the said order was passed without giving an opportunity of being heard to the petitioner. And as such, Mr. Decker has contended to set aside the same. However, Ms. Ite, learned additional senior government advocate, submits that it is in the domain of the respondent authorities to restrict the market. However, she admits that the aforesaid order was passed without giving an opportunity of being heard to the petitioner. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that let notice be issued to the respondent returnable in 4 weeks. However, no formal notice is required to be issued since Ms. Ite entered appearance and received notice for all the respondents, but extra requisite copy of the petition be furnished to her during the course of the day. And pending further consideration, the impugn order dated 9th of March 2026 state till returnable date, list after 4 weeks.
I'm obliged.
Item number 4.
May I please, Your Lordship? So my contention of this writ petition is, I am the contractual driver under the Arunachal State Electricity Regulatory Commission. I have been working since 3rd January 2017 till date of my retrenchment termination, 6/1/2026. But I have been retrenched in such a way, the secretary of the commission asked me to present before him, and immediately he said that your termination is over, and from tomorrow onward you have no service. So in this way, saying he hands
What is wrong with the order?
the order that is
Admittedly, you were in contractual job,
contractual job.
and contractual period was till the date of
Every 1 year, my contractual appointment
Yes.
is extended.
yes.
In such way, for long 9 years, I was continuously without break working. That on that particular day, that is on 6 January 2026, suddenly
You
I
have
have
been
been
terminated from service on the date on which your contractual period was over.
my contractual period was actually over by 2nd January 2026, annual contractual, and I was directed. I was given the notice on 6 January 2026. Page 19, my lord, Annexure 1. This is the termination letter order. So
The authority has refused to extend the period of contract.
yes, without any further notice. Generally,
No, what
the rules that at least I am entitled
your
to.
contractual period is only up to 2nd of January 2026.
Yes. But generally every year it is
No, maybe.
extended. But on that particular day, suddenly, I am entitled to have at least received one notice for 1 month as per rule of
As per rule of?
as per Industrial Dispute Act 1947.
No, whether Industrial Dispute Act will cover it.
Even CCS rule even provide this notice, at least 1 month notice. The 1 month notice, thereafter they may retrench me from my service, but it was not like that. In a sudden, I was shocked and surprised that immediately he asked me, you give me the key, from tomorrow onward you have no extension, your service period is, extension period is over. So at least for the interest of justice, at least I should have given 1 month notice, my lord, as per.
Yes, Mr. Lowang?
During the appointment of this petitioner was purely temporary for a period of 6 months. However, from time to time, on yearly basis, it was extended. Later on,
Yearly extended.
yes, later on they had found, wrongly they had extended his service. So on the terms and conditions, that given at the time of appointment, he had been removed, he had been terminated. Purely temporary. There was engagement on it.
It was my continuous service. That is, it was my bread and butter.
Okay,
Immediately,
let notice go at this instance.
yes, my lord.
Heard Mr. Deka, learned counsel for the petitioner, Mr. Lowang, learned government advocate, senior government advocate for the state respondent. The grievance of the petitioner is that he was appointed on contractual basis as driver under the Arunachal Pradesh State Electricity Regulatory Commission since 3rd of January 2017. 2017, and his contractual period was extended from time to time, and last such extension was made till 6th of January No, till 2nd of January 2026.
Yes.
26. Thereafter, he was terminated from service with effect from 6/1, no, on 6/1/2026. 2026. Mr. Decker further submits that the petitioner is the sole breadwinner of his family,
Yes.
and also he has the burden of looking after his wife and two minor school-going children and old ailing parents. And the respondent authorities have has terminated his contract without giving any notice, though he is entitled to 1 month notice as per CCS rule.
Yes, my lord.
CCS rule. And since he has been terminated without giving him any notice, the impugned termination order is liable to be interfered with. Per contra, Mr. Loang Learned senior government advocate submits that the petitioner was appointed purely on contractual basis, and after the end of the contractual period, he has been terminated from service. And as such, the impugned order suffers from no infirmity or irregularity requiring any interference of this court. Whereas the submission of learned counsel for both the parties needs further consideration at this stage. Notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since Mr. Loang entered appearance for all the respondents and received notice, but an extra requisite copy of the petition will be furnished to him during the course of the day. List the matter after 4 weeks.
Must.
Item number 5.
Yes,
That's
yes,
yesterday's matter.
Yes.
Yes.
Where is that notification?
The notification is here, my lord. May I have it? Office memorandum dated 11 September 1998. My lord, operative paragraph is paragraph 4, my lord. Paragraph 4. May I read, my lord? The question of rationalization and further liberalization of the
Existing schemes.
assisting scheme and
Guidelines
of the increase of the military and extremist activities in different parts of the country. The 5th Central Pay Commission having been appointed, in the meantime, the commission has been requested to examine the existing benefits, available terms, various schemes and guidelines, and to recommend a comprehensive policy that could be adopted in regard to ex gratia payment in the cases of death of various circumstances in any part of the country which could replace all isolated decisions that might have been taken in the past of the government by various individuals. Oh, sorry, my lord. Actually, it should be para 9(9), my lord. Para 9, my lord. The order shall apply to all cases of death in harness occurring on or after August 1, 1997, insofar as cases of death which occurred prior to August 1, 1997 are concerned. These shall be regulated and finalized in terms of the orders and instruction in force period of the issue of this order. This order was passed in the year 1998, but though my husband expired in the Operation Rock Sock against the militants in the 1992, but this order is attracted because with retrospective effect according to the para 9, my lord. This is a central government notification. By this notification, I am entitled at least 5 lakh rupees as ex gratia. Therefore, my humble prayer before your lordship.
No. In which paragraph of this office memorandum it is provided that you are entitled to 5 lakhs as compensation?
Paragraph 5. This is attracted in my
paragraph number 5.
Yes. In separation of all earlier orders issued by the government as well as by the individual ministries and departments, insofar as this relates to the payment of an ex gratia lump sum compensation in certain.
Yeah, so who is appearing for Union of India?
I am appearing for the Union of India.
Are you aware of this notification?
No, my lord. In fact, I have
No.
gone through, my lord.
Better you do one thing, Mr. Deka, you furnish a copy to him.
Yes, ma'am.
Let him obtain instruction in respect of this clause number 5 and 9.
Yes, ma'am.
We will hear the matter on Friday.
Okay, ma'am.
Next Friday?
Next Friday will be too early because these official respondents are residing at Shillong. Then the head of the Assam Rifle is Shillong.
Next week?
A week time.
Week time. Okay. Heard, Mr. Deka, learned counsel for the petitioner, and Mr. Kato, learned Deputy Solicitor General of India for the state for the respondent number
1, 2, and 3.
1, 2, and 3, and Ms. Wangmo for
4 and 5, my lord.
4 and 5.
Yes, sir.
4 and 5. During the course of deliberation, Mr. Deka has placed before this court one office memorandum dated 11th of September 1998, and on the basis of the said office memorandum, he submits that as per clause number 5 of the said notification, and also in view of the clause number 9 of the said notification, the petitioner herein is entitled to ex gratia compensation amounting rupees 5 lakhs. 5 lakhs. Let a copy of the memorandum be furnished to Mr. Kato, learned Deputy Solicitor General of India, so as to enable him to obtain a specific instruction in respect of paragraph number 5 and 9 of the said office memorandum dated 11 September 1998. Recess shall list the matter on next Wednesday. Obvious.
Item number 6.
May I please, my lord? My lord, here the petitioner has been terminated from service. My lord, without the following due process of law. While he was at the training at the Bandardua, my lord.
No, maybe at that time you were in probation.
Yes. Actually, my lord, I was under training at the Bandardua at that time.
No, maybe, but you were under probation. Your probation period was not over.
Oh, my lord, because actually my service was not confirmed at that time.
That's why you were under probation.
Yes, my lord, here.
Only after successful completion of the probation period, your service would have been confirmed.
Confirmed. Even though, my lord, here the main ground for termination is that I have suppressed the material facts, information.
Yes, one case was registered against you.
Yes, that case was already discharged by the Honorable Court. The case was a PT case, my lord. That is, my lord, kindly.
How it is petty case? You have been seated under section 384 of the IPC.
No, 419, my lord. 419, my lord. Kindly turn, my lord, my replication petition, my lord. Replication test 112. Bear it, my lord.
No.
Replication 112.
Where is your termination order?
Termination order is, my lord, page 44.
Yes.
Of my writ petition.
Yes. So you see, it is a SOI PS case number 26 of 2019 under section 384 506 34 IPC.
Yes, this was dropped by the court.
Yes.
That's why in this case, replication, my lord, page 112. Page 112. Get it?
Got it.
Yes.
But where is the search framing order?
There's search.
Or the search sheet, where is the search sheet?
Search sheet is, my lord, not here, but this is at the CC stage. CC stage, it was discharged. Discharged by
No, we have to see under which provision of law you have been search sheeted.
Search sheet, these records are not there. Even though, my lord, here.
You produce the certified copy of that order?
Yes.
The certified copy of the search sheet?
Search sheet. My lord, I have
As per this annexure number 2, you have been search sheeted under section 384 506 34 IPC.
Yes.
You see the last line, the case has been search sheeted and it is currently on trial. You produce the certified copy of the order, we see. And when this discharge order was passed?
This
on
was 6/6/24.
24, and when the impugn order was passed?
Impugn order was passed on 23 July 24.
23 July
July
2024.
You know, here the termination order, before issuing of termination order, though there was a suppression of the facts, even though, my lord, they cannot be terminated arbitrarily because they have not providing any opportunity of hearing.
No,
Also.
since you are in probation, they are not bound to afford you an opportunity of being heard during the probation period.
My lord, just here, I am just completed the physical training, and after that, I was at under training. Training was not completed.
Maybe.
At that 11 point of time.
Maybe.
And then during that period, they're saying that you have suppressed the matter.
You see, there is no requirement that to terminate you from service, you have to complete your training.
Even though, my lord, that's at least they should not terminate me arbitrarily because opportunity at least should be given. Without following due process of law, I cannot be terminated. My humble prayer is that.
No, had your service been regularized after successful completion of the probation period, then the matter would have been different. Yes, madam, what is your stand?
Just
You have filed affidavit here?
Yes, Lordship. Yes,
What is the stand of the department?
Department, Lordship, in the character and antecedent form, Lordship, where he have concealed the facts, Lordship, where he have said no instead of yes. Lordship, it was signed on, it was filled on 18 to 2024. Lordship.
This application
Form 18 to 2024, whereas the judgment of the CJM Pasihat is of 6/6/24. So it was very much alive at that point of time. Lordship. The matter was. So he have concealed that. And in the, especially in this disciplinary police department, Lordship, character is antecedent is very important. Suppressing of material, Lordship, in catenas of judgments, Lordship. It has been reported so many. I will give only one, Lordship. And then, as Lordship have rightly pointed out, Lordship, they were just in this one provisional period. Only 3-4 months they were there in the
training,
Lordship. Yes, Lordship. And then when it was found out, Lordship, 3 of them were there. All of them were Lordship termination. But then other 2, because they were Lordship, the cases were of juvenile period. Their cases were different and they have been considered by this honorable court, Lordship.
My lord,
They were also before this court.
My lord, already along with other two persons, they have already approached this court and their petition has been allowed. And the other was in juvenile, and the other was a witness at that time of committing the offense. And they have also concealed the information, and this court has allowed a petition, my lord.
That is Lordship, that because they
No,
were
just for reference,
both of them were
this is
juvenile, Lordship, at that point of time. Lordship. So as per the law, Lordship, juvenile and anything, the Lordship, it cannot be counted, Lordship. So that has been considered by this honorable court, Lordship. Lordship, in Lordship, this.
Anyway, here in the order of the trial court, it appears that section 419
Yes, my lord.
has been mentioned. But from the annexer to it appears that charge sheet was submitted under section 384. So you produce a certified copy. We'll take it up on next week, in the next week.
Certified copy of
Certified copy of the charge sheet. Charge sheet. And madam, you also ascertain whether during the probation period a notice is required to be given to the petitioner or not.
Lots,
Both of you
lots,
find out the law point.
lots.
Heard, Mr.
Titaki.
T. Tapak, learned
Titaki. Taki.
T.
Taki.
Taki, learned counsel for the petitioner. Miss Ite, oh, the state respondent. During the course of deliberation, the learned counsel for the petitioner has pointed out that though a case was registered against the petitioner and the same was surseated, yet before the impugned order being passed, the petitioner was discharged by the Court of Learned
CGM. Pasigat.
CGM UPI.
Pasigat.
Pasigat. CGM Pasigat. And the said order is enclosed with the petition at page number
Paste. Page number 112. 112.
page number
112.
112 of the petition.
Replication.
Replication. And further, it appears that the said order was passed by the learned CGM Pasigat on 6/6/2024 by holding that the offense of the that the petitioner was acquitted for the offense under section 419/506 IPC, whereas the annexer number 2 no, that order 1 you have also enclosed one. That handwritten portion,
Yes, 113 Lordship.
113.
13.
But from the annexer number 2 of the replication, which was issued by the officer in charge, Oyan Police Station. What is the name of this police station?
Oyan Police Station.
Sile Oyan.
Sile Oyan.
Sile Oyang Police Station, Pasigat, East Siang District,
Yes, sir.
reveals that charge sheet was submitted in Soy PS case number 26 of 2019 under section 384/506/34 IPC. In that view of the matter, it is provided that the learned counsel for the petitioner shall place on record the charge sheet submitted, certified copy of the charge sheet submitted against the petitioner before the Court of Learned Chief Judicial Magistrate Pasigat on next date. Rest shall list the matter on when?
Maybe on 17. 26.
26. 26 March 2026.
Plus.
Obliged.
Item number 7.
Lordship. This case is Lordship, the petitioners are this contingency worker. Contingency worker, they have been appointed, Lordship, kindly see, as per due process of law. This is kindly see, page number 32, Annex 4 of the WP. There was a walk-in interview was conducted for appointment of the petitioners, and they're eligible to be appointed at a side post. Accordingly, Lordship, in terms of this walk-in interview, board was constituted, in which they have been appointed. Kindly see the page number 34, Annex number 6 of the WP. There are 14 number of these appointees. Accordingly, Lordship, they have been engaged. And during the course of engagement, previously their monthly wages was also released by the respondent authority. And in the meanwhile, period, kindly see page number 37, Annex number 9. Page number 37, Annex number 9. This is this is the letter.
What is your prayer in this petition?
My prayer is for release of the one is for setting aside of the impugn order, and another is for release of the release of the pending wages. Pending wages. Kindly see page number.
Where is the impugn order?
Impugn order is Lordship. This
31.
31. 31, okay?
नहीं
31 ना?
नहीं है पुराना
Annexer
It is a letter
15,
dated
page number
impugn order is
74.
letter dated 8 April 2025. 8 April 2025 is page number 37.
Page number
37. 37.
37.
Yes. This is the only the letter. No final order is passed. Even then, this is the what I was submitting. As for this, in the string of this letter written by the conservator of forest planning, he has written an application to the director of Forest Research Institute, Simpu, Itanagar, saying that in continuation to the letter and the reference and subject cited above, I am directed to forward it here with a copy of the letter received from Honorable MLA Doimuk. In the meanwhile, I am submitting Lordship. While I was we were working in the department, this Honorable MLA written a DO letter stating that there is a huge irregularities in appointment of the petitioner. Accordingly, this letter was forwarded to on the basis of the complaint of the MLA, Honorable MLA. This letter has been forwarded to the director saying that engagement order should be held as per this operative portion. Kindly see. As informed earlier, I once again directed you to keep all discontinuation order and engagement orders on hold till this office receive proper instruction from the state government. This is the only issue.
Whether it can be said that by this order your service was terminated?
No termination laws.
Then you are still working?
Yes.
But your salary has not been paid?
Yes.
Now your pair is to set aside this order?
Yes. Because Lordship, because it has to be set aside, because Lordship, I have been appointed under due process of law,
And this is the illegal interference of the honorable MLA, saying that there is irregularities, there is the corruption, saying that it requires to be investigated, whereas there is no such investigation agenda from this government department. And on the record, Lordship, kindly see, on record, what is my post? Kindly see, this is the office memorandum, annexure number 1 can be seen, Lordship. As per the honorable, this annexure number 1, page number 28, there was a cabinet decision saying that the contingency or casual staff who has exceeded the 60 years of age, who has crossed the 60 years of age, that required to be relieved from the department. Accordingly, this office OM was issued by the Chief Secretary, Government of Arunachal Pradesh on 28 February 2025. Accordingly, in pursuance of
Mr. Tapak, you see, by this letter,
yes,
discontinuation order and engagement orders are put on hold.
Yes, put on hold.
And if your engagement order is put on hold, are you discharging the work now?
Yes.
On what basis? And how?
Kindly see, after this order, this is not order, this is a letter. After issuance of this letter, this kindly see, this government has released our salary also, and the authority has written. This page number 38, annexure number 10 may be seen. This is State Forest Research Institute. Kindly see.
Yes.
Yes. And any inconveniences to all concerned is regretted due to repeated instruction received from the PCCF office from which it is kept on hold. Even then, later on, kindly see page number 39, annexure number 1, who is the appointing authority. This Director State Forest Research. After this, putting the matter on hold, appointment on hold, kindly see, that is in the proceeding, it is, this letter is on 5 May 2025. May I read the contents regarding office circular that I have referred to. As per your above circular and in compliance of your letter circulation of OM notification such as by 5th March 2020, it is observed that officers follow the entire norms for engaging 14 numbers of contingency staff against 60 plus aged after this continuation, whereas your office has directed this office to keep the engagement letter to keep on hold by letter number such and such. Accordingly, which this office has kept the engagement health letter such and such, what I have referred to. In this connection, this office has followed the due process by constituting a selection committee, and the action taken thereon this matter is enclosed below. This continuation order such and such, circular number such and office such. Therefore, your good office is requested to call back the officer's written to the Director PCCF, call back or cancel the health letter issued to this office and entertain the select list by uploading the names in the PMS portal and release their wages amount such and such 3.5 lakh for 14 people should be credited against. Accordingly, after this health letter, this respondent authority has released the salary, this our wages. Then what happened after release of this for some period, some months of wages of these petitioners, that it was again discontinued.
No. Here it is stated that should be credited against 14 numbers of 60 plus contingency.
Yes,
account.
where are the 14 numbers?
So whether this amount was credited to in your account?
Yes. I have kept the records, this, enclosed the records. Page number 45.
And for how many months you have not been paid?
I have not been paid. I have recorded this. There is a specific error, man. This money was released for only 2 months, 19 days, and the rest of the amount is yet to be released. 2 months, 19 days wages was released by the respondent department. And the rest of the amount is still pending. Because there was a hold, direction was issued for holding. Accordingly, it is kept on hold till that. That is where we are facing difficulties to manage our family. Whereas there is nothing, any poor play, and all the procedures has, the appointing authority has clearly written that the due process has been followed. Due process has been followed. In the government affidavit also, process has been followed. Because this is a walk-in interview about the vacant post. Accordingly, we have been appointed. Then we have been, after appointment,
Whether the state government has any rule regarding recruitment of this grade 4 staffs?
Lordship, contingency, especially contingencies. These 14 contingency who are before this honorable court, Lordship, especially, they are against the post who have been
Retired.
After they have attained 60 years. Lordship. Basically, Lordship, age followed in this case. Lordship. Walk-in interview is taken, Lordship.
No, whether the rules allow the walk-in interview for contingency post?
Contingency post, according to the need of the department, especially in this, Lordship, we'll see here in just a second, Lordship. My affidavit by the director, Lordship, is specific. Para 19, Lordship. Here, the contingency, Lordship, is this work has been given on need based like this, especially since this is forest department, Lordship. Gardening, watering, gatekeeper, chokidar, mali, and sweeper, Lordship. This cannot be kept vacant because the Lordship, mali, sweeper, chokidar, especially gate chokidar, Lordship, these are needed, Lordship. On need based, Lordship, they are taken, Lordship. But then here in this case, especially, Lordship, the director has called the interview and he have appointed these 14 numbers in place of this already relieved 14 overage persons, Lordship. But then in between the Lordship, the conservator of forest, Lordship, they have issued this letter to the director because, Lordship, my paragraph 6, Lordship, in paragraph 6, they have said that the department, they have received a letter from Department of Vigilance asking for the answer why they have illegally appointed 14 contingent workers. So because of that, Lordship, because of this letter, Lordship, we have annexed this letter also. Because of this letter, it has to be held. The hold letter has to be given, Lordship.
No, if the director of the institute can appoint such person on contingency basis.
Yes, Lordship.
Then whether on the basis of the letter of the MLA.
Not MLA, but then vigilance we have said, Lordship. MLA, Lordship, of course, concerned MLA can interfere, but for MLA, the department cannot issue a halt, Lordship, termination letter or whatever, Lordship. This is we
then
say,
why their salaries have not been paid?
Lordship, Lordship, may kindly come to my paragraph 6, Lordship,
Of the affidavit.
of the affidavit filed by respondent number 2, 3, and 4. Director is 5. Director is with the petitioners, Lordship, of course, and this hot letter has come from this respondent number 2, Lordship.
Paragraph number 5.
6.
6.
Lordship, here we say that Lordship, the answering respondent begs to state the clear instruction to put on hold the fresh engagement against vacancy arising out of disengagement of those contingencies who have attained 60 years of age was issued to the director SFRI. This is the director by letter so and so, dated 4th April 2025. Further, on receipt of several complaints alleging illegal engagement of 14 contingent workers by the director SFRI, the Department of Vigilance, Govt. AP, has also sought response from the Forest Department. Accordingly, instructions to put on hold the engagement by this office letter so and so was reiterated by dated June 2025. This is the second letter issued to the director, Lordship. Earlier, first letter was given, sent to him on 4th April 2025 to put on hold all the orders.
Are they working now?
The Lordship, after the hold letter,
They are not working.
they are not working.
We are working, Lordship. This is on expectation, Lordship. We have been engaged, Lordship.
Lordship, this
Because
director,
it's a labor work.
of course, this respondent number 5 was telling that this post cannot be kept unattended, Lordship, because Mali, the plants will die.
This is
All
daily
those-
work in a
all
vacant
those
post.
problems were, Lordship, being Lordship stated, Lordship. Chowkidar, Mali, and then Lordship. Whatever post is mentioned. Since these are very important posts, Lordship. So they may be working, may not be working. Till that, I haven't taken instruction, Lordship, to that effect.
Lordship, only the problem is, Lordship, the MLA note is the root cause, Lordship.
No, Lordship, that's just an
That is
allegation.
No, there
because
is one letter of the Vigilance Department also.
No,
Vigilance
there is
Department and
no-
Lordship, and from the Anti-Corruption Bureau,
No.
Lordship.
No letter, no FIR from Vigilance Department agent that. Only the MLA letter, Lordship. MLA,
No,
your note.
No, no.
Tapak, you come to this paragraph number 6.
Kindly see, Lordship, in the government affidavit, there is no any FIR, no department
No,
reporting
that's
against,
all right.
except the Everman, Lordship,
Yes.
except the Everman.
Hmm.
There is nothing any such record, Lordship. Without record, that cannot be believed, Lordship. Because if there is a erring officer, there should be departmental inquiry as per the process of law. Or if there is a corruption case alleged by the MLA, there should be a registration of FIR under the PCA. But nothing has been done except the baseless allegation, Lordship, saying that there was a
Whether
irregularity.
the MLA is a party here?
Who, Lordship?
MLA?
No, MLA is not a party. That is
Okay.
why I am not phrasing, Lordship, because I am to say, Lordship, my appointment, our appointment was done as per the due process of law. Circular was issued, a notification was issued, and we have been called for, we have applied for, and walk-in interview was conducted, and accordingly we have been appointed. Then we have been, after appointment, our even wages was released for 2 months and 19 days. And this government letter has come saying that it should be put on hold because MLA has made a complaint. That is the only issue. And we have been engaged by the director saying that this director, the appointing authority, even requested the higher authority saying that this post cannot be kept vacant because that is a mali, watering and everything. This labor work, who will do that? That is the issue here. So, Lordship, I am to pray this honorable court, Lordship, this impugn order may be passed, order may be set aside, impugn letter that may be set aside, and this pending wages of the petitioners may be released because we are poor people.
No,
engaged in contractual-
this annexure number 9 is
And-
a letter of the conservator of forest.
Yes, Annexure 9.
Annexure 9.
Yes, conservator forest.
And where is the letter of the MLA?
MLA, we have not been punished, Lordship. That is why. We have
You
been
not
told
been
that
punished.
some MLA has, even we have not seen the letter. The authority has told us that one MLA has made a complaint. That is why he has this IFS conservator forest has referred to
Madam,
MLA now. You know.
that letter is also not part of your affidavit.
Yes.
No, Lordship.
Not a part of affidavit.
Is it
We have
available?
only stated that this is not under the instruction from the MLA. Only that we have
Yes.
stated that.
Not under the instruction.
Yes.
From the MLA. In the statement.
Yes.
In your affidavit.
Yes.
Not under the instruction of the MLA.
MLA.
That is your averment.
Aberment, yes. Only
Then
that-
what is
because
then?
there was a complaint, there was a Lordship in 234, Lordship, in paragraph 11 also we have said that it is not a fact that the newly engaged contingency staff were kept on hold on the basis of DO letter by Honorable MLA, Doimuk Assembly constituency.
But the DO letter reference is there in the Annexure 9.
Yes. Annexure.
Yes, I have seen, Lordship.
Yes.
I have already seen, Lordship. But then in the statement, because they have said so, Lordship, para 11, by 2, 3, and 4. The instruction for keeping the appointment of contingency staff on hold was issued by this office letter so and so dated 4th April 22 for want of clarification from the government regarding process of disengagement so and so. They have said this on.
If that is your affidavit,
This is my affidavit, and
then
of
this
your-
letter of the conservator of forest, which
Yes,
is impugned
whereas-
in this, which is impugned in this petition, has no basis.
Lordship, in this statement also we have talked about the DO letter that it is not a fact that newly engaged so and so kept on hold on the basis of the DO letter by Honorable MLA. We have said that.
Okay, then we will set aside this order, this letter, 8 April letter.
Lordship, I leave it to your Lordship.
And
Otherwise,
release their
Lordship,
salary.
Lordship, otherwise the latest development is none of the contingency workers are getting their pay this month.
No, that's all right. You have to pay them.
Lordship.
So by setting aside this impugn order,
Lordship.
impugn letter,
Lordship.
we will also direct you to pay the remuneration of the petitioners.
Lordship.
What to do then? This is the only way.
Lordship.
If your own affidavit says that the DO letter of the MLA is not the basis of
Yes.
holding their for keeping on hold their
Only
appointment and
complaint
also the
was the
salary.
Anti-Corruption Bureau and the Vigilance Department. Because of them only it has been held.
No,
That
there
is
is no FIR, no
Yes,
complaint,
yes. There is no record to show.
and that letter is also not enclosed here.
In my
Affidavit.
Lordship.
Only the statement.
Yes, Lordship.
We allow this petition.
Oh, like yours.
Next one.
Item number 9.
Okay, yeah. Lordship, this petition is Lordship, second round of writ petition, Lordship. Kindly see page number 31, Annex 10. As per the direction of this honorable court has given direction for disposal of this representation of the petitioner.
No, Mr. Tapak, you see, if the direction issued by this court in a writ petition has not been complied with,
Yes.
what is the remedy?
Remedy is Lordship, kindly see. This, as per this,
No,
previous-
the remedy is you should have filed one contempt petition against them.
no Lordship.
Whether this writ petition is the answer to the same.
Region has been cited, Lordship, by the Deputy Commissioner, saying that you are not under the Lordship recruitment rule. You are not qualified. That is the issue. Only the confusion is over the recruitment rule. Whereas in this writ petition, previous writ petition, I have challenged my senior, saying that I should have been promoted to the higher post. In the meantime, my senior has died. So I was expecting I will be appointed in his post. But when the honorable court has given a direction for disposal of my representation on merit, the concerned authority, that is the Deputy Commissioner, who is the appointing authority, saying that you cannot be appointed because rule is against you. You are not eligible under the recruitment rule. That is the only issue. Saying that there is one office memorandum, page number 41, annexure number 14 is the disposal order of the writ petition, my representation. Kindly see, operative portion is 42, last paragraph. Page 42. Yes, considering above present circumstances of the case, I am of the opinion that the applicant Lumane Melo, PI grade 1 of this office is not eligible for promotion to the post of PA. PA Group B gazetted. PM is political assistant. For want of minimum prescribed educational qualification as notified by the government in its office memorandum such and such, it is subsequent corrigendum such and such, accordingly representation of the petitioner dated such and such is then disposed of. My
Okay,
representation
this order is the impugn order.
Yes,
Okay.
saying that there is a misunderstanding of the misinterpretation and misunderstanding of the recruitment rule. Whereas my recruitment rule for appointment to the post.
So what is the qualification for being appointed as PI grade 1?
That is as per the page number 24, annexure number 6. Kindly see, this is a
PI grade 1 to
this is
PA.
yes, standing notification
Page
for
number?
appointment of PA, political assistant.
Page number?
Page number 24, annexure number 5. This
24.
provision has been misunderstood by the Deputy Commissioner, saying that you are not eligible because there is a standing office memorandum. Office
Okay.
memorandum cannot prevail over the recruitment rule also. When memorandum, this recruitment rule is clear, may I read the contents of this recruitment rule? This is a source of appointment of the political assistant. Appointment to the cadre of political assistant will be made from the serving interpreter grade 1. I am grade 1 in the department. An area superintendent belonging to Nepa tribe, we are Nepa tribe, and now Nepa tribe of the agency level, taking due care that district and tribe are duly represented in the service as per as possible on the basis of the merit cum seniority on the recommendation of the DPC. Kindly see what is the eligibility criteria. Kindly see last down below, provided that no person shall be recommended under the sub rule, nor the DPC shall select any such person unless recommended
recommending authority and the DPC as the case may be has taken into consideration of the following aspect of the candidate, this is the eligibility criteria. The opinion of the deputy commissioner was I should be graduate, whereas as per this recruitment rule, PI, this is all practice legacy, British legacy. Personality and character has to be seen. And fact inquiry, general intelligence has to be seen. And one is integrity and influence on his own tribe as well as on another tribe. His service can more profitably be utilized by appointment to the cadre of political assistant. Physical fitness, executive ability, any special weightage for a more backward or sensitive area within NEPA. This is the only criteria prescribed to be appointed for political assistant as per the recruitment rule. And this recruitment rule has never been modified by way of executive, specifically by way of executive notification. And this RRS is still standing in the department for appointment of this. And post
In this role, the qualification, educational qualification has not been prescribed.
Prescribed. That is not required.
Not required
yes,
for
as per-
political assistant.
Yes.
Okay. And where is that office memorandum dated 29/8/2019?
Yes, that I have enclosed this
Page number
page number 46, annexure number 5.
46.
This is type copy. This is a office memorandum issued by the Department of Administrative Reform, 29 August 2019. Fixing for graduation, bachelor degree as basic educational qualification for appointment in Group A, Group B post.
No, Mr. Tapak, you see, though it has not been provided in the rule
Yes.
dated 18th of October 1967,
Yes.
yet since it has not been provided, the government has issued the OM.
Specifically, Lordship, kindly corrigendum. This corrigendum can be seen, Lordship. This is
Corrigendum at page number?
page number 49 is there. Annexure number
49.
11.
49.
This is for technical department, Lordship. Not for this. This generally political assistant is the assisting the deputy commissioner didn't, and now also there of this office has been continued by the government of Arunachal Pradesh. Although this is a group B in just namesake, but it is a category is under Group C in terms of salary and all. So until and unless specific this executive notification with regard to appointment of this political assistant, or
No, the question is whether
can prevail.
No, that cannot prevail, but they can supplement
Yes.
since it is not provided in the rule. This rule is made under 309, Mr. Topin,
Lordship, this
by the governor.
Before that, Lordship, I wanted to submit, Lordship. That may be seen, page number 27, annexure number 7, Lordship. What is this post? Political assistant post. The governor may read the content.
No.
This may be seen before that, before proceed to the government advocate.
Page number?
Page number 27, annexure number 7. The governor of Arunachal Pradesh is pleased to order that creation of PI, political interpreter, post shall be considered on need based in principle. All existing sanctioned posts of PI lying vacant unutilized at any place may be diverted and transferred to other place where it is felt necessary. This PI is generally used in the backward.
No, that's all right. We are not concerned with that.
And before that, kindly see page number 26, annexation number 5. This is a group, not the group B. It is a talent under the group C.
Okay.
And page number 26 may be seen. Governor of Arunachal Pradesh is pleased to order that present rank and status attached to the political assistant shall continue to be group B gazetted. All the pay and structure attached to the post head talent under group C. It is a group C category.
Maybe.
Yeah.
The question is, whether the government can prescribe qualification which is not provided in the rule or not.
Yes.
Yes, Mr. Tapin, what is your stand?
On this particular point, Lordship, earlier Lordship, this honorable court has already examined and already decided that Lordship, in case if the recruitment rule is silent on the education qualification in case of the promotion, Lordship. In that case, Lordship, if there's an executive order, Lordship, that can supplement the recruitment rule. Whether this recruitment rule and the executive order, whether they can dwell together or not, that is to be considered by the court, Lordship. Here, in this case, also like in earlier case, Lordship, recruitment rule is silent on the education qualification. If it says, Lordship, education qualification cannot be prescribed, if that language is there, then we cannot, Lordship, by executive order, we cannot, Lordship, read in that, we can modify that rule, Lordship. But if that is silent, Lordship, then, Lordship, this executive order can be, Lordship, read in. For the Lordship, to higher the standard of group A and B, Lordship. On this particular point, Lordship, this is a judgment of Lordship on this very Lordship Office Memorandum of 2014, 19 and 24, Lordship. Same Office Memorandum, Lordship.
Okay.
This judgment of Lordship. Kindly come to the judgment in the read petition, Lordship. This is the judgment passed by Lordship only. Paragraph 12, Lordship. Paragraph 12. Same issue was considered by this honorable court. It appears that the principal ground on which the impugned action in both the read petitions were assailed is the education qualifications for promotions of APPS grade 1 from APPS entry grade as provided in Arunachal Pradesh Police Service Rules 1989 and Amendment Rules 2006, which regulates the method of promotions for the post of APPS grade. It is to be noted here that the said rule did not provide for any education qualification. There is no quarrel at the bar in this regard. It is to be mentioned here that the qualifications provided under the said rule is only 5 years service in the entry grade, Lordship. Education qualification was not there, Lordship. So it is to be this issue after consideration, Lordship. The Lordship has dismissed the read petition, Lordship. Because here, Lordship, petitioner case was not considered because they were not graduated, Lordship. They were not graduate, Lordship. So accordingly dismissed, Lordship. Then they challenged it before the Honorable Division Bench, Lordship. The other one, Lordship. The same, Lordship, this Honorable Court, Division Bench of this Honorable Court dismissed the read appeal filed by the read petitioner, Lordship. Lordship can see paragraph 13, 14, 20, 21, Lordship. So the same issue was already considered. And in the present case also, kindly come to page, Lordship, 22, Lordship. Page 22. Page 22 is the, Lordship, seniority list, Lordship. If Lordship see the petitioner's name at serial number 1, PI grade 1, Lordship. At serial number 1 is the Lumen Melo. Lordship will find education qualification is class 3, Lordship. It's a class 3 pass, Lordship. The petitioner, Lordship.
And as per the OM, it is graduation.
Graduation. And kindly come to Lordship, page 26, Lordship. Page 26, Lordship. This 2000 notification order, Lordship. The governor of Arunachal Pradesh is pleased to order that the present rank and status attached to the post of political assistant shall continue to be a Group B gazetted, Lordship. This is a Group B gazetted, Lordship. And so far, this office memorandum of 2014, which was, Lordship, kept in abeyance for 4 years, allowing all the serving employees to, Lordship, go for further studies, Lordship. Then it has been reintroduced in 2019, Lordship. Thereafter, 2024, it has been reiterated, Lordship. The Group B and Group A, Lordship. Graduation is compulsory for each and every, Lordship, promoted.
Okay.
So here the Group B, the petition at the post of the political assistant is belongs to Group B, Lordship, gazetted, that to gazetted, Lordship. Now he is a class 3 pass, Lordship. And impugn order, which is under challenge in the present writ petition, because earlier, Lordship, in earlier round of litigation, this Honorable Court has directed the authority to consider his representation, Lordship. Accordingly, it has been answered
By passing the
the region order. There is, it has been stated, Lordship, the post belong to the Group B, Lordship, where the education qualification is given, Lordship, as per the office memorandum of 2019. That's the original office memorandum is 2014, Lordship. Then it was kept in abeyance for 4 years, Lordship, and then in 2019 it was reintroduced, Lordship. So citing all those grounds, Lordship, this region order has been passed rejecting the case of the petitioner, Lordship. This is the case, Lordship.
Okay.
So the law is that, Lordship, when the education qualification or any qualification is silenced in the recruitment rule, that can be supplemented by the, Lordship, executive order, unless that's contradictory to each other. If they are contradictory to each other, then, Lordship, they cannot dwell together. Then one has to be above, that is the recruitment rule, which is under 220.
So this doctrine of unoccupied field will come into play here. The doctrine is that when field is not occupied, then the government can issue office memorandum or executive order. Here, the field is not occupied. Field means this educational qualification. So the government can issue OM. Government has issued OM prescribing the educational qualification, and admittedly you did not possess the same. So therefore, by impugn order dated so and so, your pair has been rejected. So where is your case now?
Lordship, may I read the continue, Lordship, in continuation of what my friend has read, Lordship, page number 26, election number 6. This is this order of 2000 November 2000, 24 November 2000 is issued by the Chief Secretary Government of Arunachal Pradesh. Although the group is supposed to be a Group B gazetted, but it is categorized under the Group C as a special category. In that event, Lordship, this notification for Lordship, this mandate under the OM, this is only for Group B and Group A category.
Okay.
Whereas this is not a full-fledged Group B category political assistance. It's a talent under the Group C. And it is a special category who is assisting the Deputy Commissioner. It is a legacy. And the intent and purpose of this legislation, political assistance.
No.
It is
Here the salary is of Group C.
Group C.
But your grade is Group B, gazetted.
Yes. That is why I am.
So the OM will be applicable in your case also.
That is why I am not a full-fledged, because I am not getting the salary like Group B category under the government.
No, that's
That is
why
one of
the government has fixed your salary
Yes.
like the employees of Group C, but your grade is Group B gazetted.
Yes, Group B.
Hmm.
That is, and number two, my point of argument is, Lordship, in this OM notification, there is a not specifically mentioned saying that by this OM notification, it will supersede the recruitment rule of the.
No, not necessary. It is just supplementing. Supplementing.
Kindly see. This is specifically mentioned somewhere, kindly see. It's, like some posts were mentioned here, page number 47. Some were relaxed. Group B and Group B posts. Now, therefore, Governor Arunachal here is pleased to reintroduce the fixation of minimum educational qualification of bachelor degree from the recognized university. Consider Group A, B post, direct recruitment with effect from the other association. But the diploma holder in engineering, agriculture, nursing, tourism, hotel management, catering, who shall be exempted in the from the purview of the operation of this OM. Lordship, that is why some of the posts have been, Lordship, not applied. Some of the posts have not been applied in case of some except general category this post. Some general category post. Like in the. That is why, Lordship. In case this OM is supposed to be applied in my case, there should have been specific mention saying that it will prevail over this
Recruitment rule.
recruitment rule.
No, you are
Or
repeating
this is
the same thing.
in supplement of this recruitment.
No, not necessary, not required.
And above all, Lordship, at that point of time, my senior was there who has died. He was also having no educational qualification, no graduation. Even then, the authority has appointed. When my turn comes, the authority refused to appoint me, saying that you do not have any educational qualification. That is, I have been singled out, Lordship. Whereas
No.
recruitment,
That negative principle of negative equality cannot be applied here. If wrongly granted anybody else, that cannot be granted to you also.
Lordship, I'm not praying for negative, in this case, negative equality, Lord. I am saying it was a practice. It was a practice because that practice was supported by this recruitment rule of the political assistant. That is my submission, Lord. And the intent and purpose of the legislation is without any educational qualification.
No, this rule was made by the governor.
Yes, governor.
Governor.
There is an issue here. Only issue is whether that the office memorandum will prevail over this recruitment rule.
No, the question of prevailing over does not arise. Because in the recruitment rule, the educational qualification for being appointed as political assistant has not been prescribed. And therefore, the field is unoccupied. So, in case of field of unoccupied, the government can issue executive order or office memorandum. And they have issued the office memorandum.
Lordship, I will make this submit the written argument. Met order may be reserved, Lordship. And in the meantime, Lordship.
No, Mr.
Submit the citation.
Mr. Tapak, you see, your written argument will not change the legal position.
Yes, that is here. That is why
So, your written argument will not advance your case.
Yes. I will.
So, what purpose will be served by filing written argument? Okay, if you want to file, you can file it.
Yes, file along with the written argument, along with this over the citation over the this
Yes, in written
over
argument,
the-
you can
there's no
always,
point saying that the whether this OM will prevail over this recruitment rule
Mm.
unless it is specifically mentioned over that issue.
Mm.
I will. Because if it was a prevailing practice, I was hopeful that I will be appointed. Even then, the deputy commissioner has rejected my prayer.
No, you see,
Foreign-
Deputy Commissioner cannot ignore the OM issued by the government.
It was the,
He has to act within the legal framework.
yes, yes,
He cannot go beyond that.
yes. Deputy commissioner has this express his own mind. And
Okay.
yes,
Heard Mr. T. Tapak, learned counsel for the petitioner. Mr. S. Tapin, learned senior government advocate for the state respondent. Argument concluded, order reserved.
I will cite,
Yes.
I will
Yes.
submit my citation.
By tomorrow.
Tomorrow.
Yes.
Item number 11.
I am appearing for respondent number 2, 3, 7, and 8, and I have already filed my affidavit in opposition.
Petitioner is absent.
Yes.
None appears for the petitioner on call. However, Mr. Tarak, learned standing counsel for the respondent number
2, 3, 7, and 8.
2, 3, 7, and 8. And Ms. P. Songita for respondent number
1456,
1456 present.
15, 16, and 17.
And 15, 16, and 17. Okay. List the matter after 1 week in the event of subsequent non-representation of the petitioner, appropriate order shall follow.
Yeah, obliged.
Item number 13.
Please, my lord. Lord, I'm appearing for respondent number 3 in this matter, my lord. We have filed counter. The petitioner sought time to file rejoinder, but we have not been served with anything.
But today the petitioner is absent.
It seems so, my lord.
Okay, we will adjourn the matter.
Please, it's anyhow a luxury litigation which they are contesting. It is the horse. There's very little merit, but we'll address my lord on some other day.
Okay. Okay. If next that the petitioner remain unrepresented, then we will take a call.
Please, my lord. I'm so obliged. my
None
lord.
appears for the petitioner on call. However, Mr. Your name, please.
My lord, I am Kumar Kisle, along with my colleague Abhijit Pandey is also logged in, my lord. We'll give the appearance in chat box, my lord.
Okay. Learned counsel for the respondent present. The learned counsel for the respondent has pointed out that though the petitioner is supposed to file affidavit in reply to the counter affidavit filed by the respondents, yet
My lord, we filed our counter in September, my lord. They have now it's been over around 6 months, my lord. More than 6 months. They've chosen not to file the rejoinder. My lord's order of 22nd.
no, they didn't file.
My lord, we had filed rejoinder. We had
No,
filed
no,
counter.
No, they have filed a reply.
We have not been served. I am the
Pointed
respondent
out
number.
that, though the petitioner has filed affidavit in reply to the counter affidavit filed by the respondents, yet no copy of the affidavit in reply has been served to them. List the matter after a week. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
Obliged, my lord.
Okay.
Item number 14.
Lordship, this I have filed interlocutory application, Lordship, in this case. For implement, my implement as a party respondent in the case. Because Lordship,
No. Who is the petitioner in the writ petition?
I'm for the petitioner, Lordship.
You are for the petition.
Yes, Lordship.
Okay. Okay.
And
Heard, Mr.
May Lordship,
Ah.
Lordship, there is no locus for them to intervene in this matter, Lordship.
Okay. We'll issue notice. You file a objection.
Lordship, in the meantime, then our interim prayer may be considered, Lordship.
Is there any urgency?
Yes, Lordship.
there is a not,
Our association has been suspended, Lordship, so cancelled, Lordship.
not a fit case for interim order.
So in the we will file our objection, Lordship, but in the meantime, interim may be granted, Lordship, because according to the last order, Lordship, it has been stated that
Okay. First, let us implead him. We'll hear him. Unless we implead him, we cannot hear him in the writ petition. Heard, Mr. T. Tapak, Learned Counsel for the applicant, and Miss
M. Bori, Lordship.
M. Boris, Learned Counsel for the opposite party number
Number
3.
Here, yes.
Opposite party number 3, and Miss Sangita for State of Arunachal Pradesh is there. Are you not representing State of Arunachal Pradesh? You are. Okay, you furnish a copy. Mr. Tapa and Ms. Sangita for the respondent number 1 and for the register. You are for the register.
No.
So register of societies, madam, you can represent for 1 and 2. For 1 and 2.
1 and 2. More, I will furnish the copy. Sir.
Ms. Sangita submits that she has not been served with a copy of this interlocutory application. That is, Mr. Tapak undertakes to furnish a copy of the same to Ms. Sangita during the course of the day. Ms. Bori submits that she may be granted some time to file objection in this application. Where allowed, rest shall list the matter. After a week. After a week.
Obliged, Lordship.
17.
Item number 15.
May I please, Your Lordship? Lordship, in this case, the conducting counsel, he has to leave the court premises for some urgent work.
Who is the conducting counsel?
Sir, R.S. Nabam.
R?
R.S. Nabam, Additional Advocate General.
R. Islam.
Nabam.
Oh, R. Nabam.
Yes. R.S. Nabam.
R. is Nabam. Okay.
Yes.
But madam, you see, this is pending since the year 2018.
Yes.
Already 8 years elapsed. Next week?
Next week it will be not possible for me, madam, because I will be out of the station for
You
1
will be
month.
out of station.
Yes, madam. Let it be on the 20 April, madam. I fixed it, maybe given, madam.
20th April.
Yes, madam.
Heard, Mr. Lampo, Learned Counsel for the petitioner, and Ms. P. Sangita, Learned Government Advocate, appearing for Mr. R.S. Nabam, Learned Additional Advocate General. Ms. Sangita submits that Mr. Nabam left the court premises on account of some urgent works, and she pressed for an adjournment of the matter. Mr. Lampo submits that the matter may be fixed on
20th April, madam. 20, madam.
28th of April. Accordingly, taking note of the submission of Learned Counsel for both the parties, it is provided that registrar shall list the matter on 20th of April.